We're going to talk about a lot of things, and I have a lot of slides. And afterwards, if you want the slides, I'll send them over to Kristen, and she can send them to you. This is training, so there's not going to be any deliberation today about specific things that have to do with your town, because other than the training part, because otherwise we would be violating the open meeting law. We don't want to do that. All right. And I'm going to tell you that this is for training, not legal advice, because each thing you have to kind of give me the actual facts, and then we'll talk about what the legal answer is, but we don't do legal advice in training. So we're going to start with the open meeting law. So what's a meeting? It's a deliberation by a public body. That's you. And by the way, we only have the select board here tonight. Nobody else decided to come?
No, we have some people in the audience. I was actually just trying to switch over to see. I have the FinCom chair here.
Great.
And I have our town accountant and our chief, but I don't know which chief. So let me bring him on over.
The chief. Only reason I mentioned that is because, you know, many of our boards do end up with open meeting law violations because they just sort of think that because they're doing what feels right, it's right. So we like to make sure that if they can't attend, they do. So a meeting is a deliberation by a public body with respect to anything that's within their jurisdiction. And it can be oral or written. It can be through any medium, including, and we've gotten a lot of violations of email, texting, and social media, because everybody does social media. That is really annoying, but somebody at my office just, there we go, we've got it stopped. So the flashing caution. So if you email each other and then you, in serial fashion, you end up, especially when you have a board of 3, it's very easy. As soon as you email one person, you've got a quorum and you've violated the open meeting law. That includes texting, emailing, social media, Facebook, Twitter, or what it's called X now, any of those things, you can actually have an open meeting law violation because you communicate with each other about a matter that's within your jurisdiction. And a quorum is just a majority. If you're a member, if you have a 3-member board, a quorum is 2. Subcommittees are also under this. So anytime you establish a subcommittee, those subcommittees are subject to the open meeting law. A one-way communication to a quorum is also a deliberation. So if you have I'm just one member and I want to tell everybody something who's on my committee or on my board, as soon as I've done that, I've violated the open meeting law. Opinions, even if it's your personal opinion, if it's a matter with which you could take some action or deliberate, that is something within your jurisdiction. So they exclude certain things. So distributing meeting agendas, that doesn't count. Distributing a schedule, can you meet on this date or that date? Those things don't violate the open meeting law. If you're going to distribute reports or documents that can be discussed at the meeting, that you can distribute them, but you can't discuss them. You can't say, oh, that was a great report, or I don't think there's enough information in that report. Nothing. No responses other than if you wanted to respond, you could say received, but no thumbs up, no thumbs down. Yeah. If you have questions, feel free to jump in because I can't see you all.
Liz, I have a question.
Sure.
So I've always been taught that if you blind copy the board and you're just sending something out informationally, as long as they don't respond to the group, that's not a violation of open meeting law. But it sounds like you can start potentially an open meeting law violation still that way.
Well, you are the town administrator. You're not a member of the board, so you can distribute things to the board, but they cannot respond to each other. They could respond individually, could respond back to you, but they cannot do a reply all. Watch those reply alls. And now because everyone uses email to speak with each other or text messages, there's going to be a record of it. You know, in the past, people picked up their packets of information and they might have talked someplace, but now there's a nice written electronic record of it.
Thank you.
A gathering is not a meeting if you don't deliberate, which is what we're doing today. We're not deliberating. If it's an on-site inspection of a project, so let's say you were doing a new DPW garage and you decided to go look at it, the old one, while you were deciding what you wanted to do. Well, that's not an open meeting. you're going to look, you can do the deliberations about what you want to do elsewhere, but you're just viewing something. So an on-site inspection. If you go to a private gathering, let's see, I would love to say that it's weddings and baby showers, but it's usually wakes. I know it sounds awful, doesn't it? But I have people deliberating in line to get in. No deliberation. But if you're just there to pay your condolences and you happen to be at the same wake for somebody who died in town, then of course that's not a deliberation. There's no violation of the open meeting law. But if you attend a public meeting, town meeting, that's not a violation. That's already done. If the school committee has a vacancy and you're holding a joint meeting, you will be posting, they would be posting to fill that vacancy. That would be a quorum and you would be posting that. That would be a meeting. And of course, session of town meeting. And for the FinCom, that applies to you as well. You have to make sure that you post any meetings where you're going to be talking about budgets and finances. So the posting is 48 hours prior to the meeting. You cannot include any Saturdays, Sundays, and legal holidays. There is an emergency exception, but it truly needs to be an emergency, not just because it would be more convenient or, gee, something important is happening and you want to get a meeting in quickly. Emergencies are things like, the roof collapsed. It needs to be conspicuous, legible, and easily understandable format. There's placement requirements. I don't think you've had any issues in your town with these, which is you can file it, you must file it with the town clerk who posts it on a website so everybody can see it 24 hours a day. She also has to have it in town hall and actually a place where people can see it during regular business hours. And if the municipality has adopted the posting online, then that would be the place for it to happen. You can't post on your own personal website and say, hey, here's the meeting and have that count. You have to include the date, the time of the meeting on the posting of the post, and also the town clerk puts the time of the posted so people can tell if your posting was less than 48 hours. And any revisions or amendments to the agenda, those actually are supposed to be within 48 hours, unless the chair of the select board or of whatever committee you're on doesn't know or could not have known about that particular agenda item 48 hours earlier. You have to put the place where the meeting will be held, and town hall is not enough. You have to say the actual street address so that those people who need to stick it into their GPS can do so. So the actual address. The topics that you expect to address with some specificity. I see people putting, and anything else that the board may consider, but anything else is not going to cut it. You actually have to list everything. The board should add the topics on the agenda that were not reasonably anticipated prior to the agenda. You can post those with less than 48 hours notice, but you really only should if you really need to address them. If you can wait till the next meeting or schedule another meeting, you should do that. People are not shy about filing open meeting law complaints anymore. The open meeting law requires that people be able to come and see and hear what you're doing, which means that you have to accommodate for an overflow crowd. Now, most of the time, I'd love to think that our community is so interested in everything we do that they're all there, but they aren't. But every now and then we do something, and we have something on the agenda that gets standing room only. I served 6 years on my school committee. I changed math curriculum, English language arts curriculum, not a lot of people. A discussion about whether we changed the first bus run and the second bus run in the morning, like what time your kid got picked up, and whether we started before or after Labor Day, standing room only, and we needed to have an overflow room because you have to be able to be sure that people can hear and see you. The public body has to accommodate its large crowd, and that might mean you'd have to move to a different space if you didn't have enough room where you usually meet. Access also has to be a place where people with disabilities, such as in a wheelchair, can actually get into the building. without having to have a lot of assistance. They have to be held. If you have noticed that someone needs a sign language interpreter, so then you would have to provide one. So we have remote participation, the sort of the pre-COVID rule, and then the post-COVID rule. So before COVID, it required authorization, which I believe your town has given. It includes participation by phone, internet, and audio, video, all of that. Now it's really Zoom or WebEx or something like that. And you have to have a quorum present at the meeting location. It's permissible only if physical attendance would be unreasonably difficult for the other member to participate. And everything, when you're doing it remotely, has to be by roll call. Now, that's sort of the default. But as we remember in COVID, we had a different rule, and that kept getting extended by the governors. And this is now extended to March 31st of 2025. We expect and hope that it will be extended past then and be a permanent change, because it does allow people who prefer to watch from their home to do so, but or while they're traveling or not away. But right now it will expire on March 31st, 2025, if it doesn't get extended. So that doesn't require any of you to be physically present. You can hold the whole meeting virtually. They have to enable the public to be able to hear and see. And if I don't think anybody's got an economic hardship after COVID with respect to having the technology. So I think that's kind of a moot point now. And all other provisions of the open meeting law apply. So the notice, the minutes, everything else remains in effect. You have to have a link for people to be able to get on to see it. So that part, the part that allows us to meet with everybody virtually and not have a quorum in the room, will expire on March 31st of 2025 if we don't get it extended. And I do think it's one of those things you should lobby the MMA to think about continuing. You can't deliberate about whether you should do that tonight, but someday you might want to. Anybody can record the open meeting part of your meeting. They have to give the chair notice, and the chair needs to tell the world that it's being recorded. By the way, when I first got on here this evening, it did say it was being recorded, but is it no longer being recorded?
It only tells you at the beginning when you log on.
But is it still being recorded? Because this is not a meeting.
It is. I can stop it. It automatically records.
I don't think
I think it's being recorded not because it's a meeting, but because it's a training that we might want to share with somebody.
Who would you want to share it with?
The department chairs and committee members who aren't necessarily present right now.
Well, I will give you the slides, because that you can have. I don't know that you want it recorded. Because everybody, we didn't announce at the beginning of, well, I guess everybody who came on got that same announcement, so they know it's being recorded.
Yeah.
Yes.
But it is not a meeting.
There is a recording icon in the upper left-hand corner telling you it's being recorded too.
Okay, well, it may show. I just can't see it right now when my screen is sharing. So after the recording, everyone can record it, but only during the open session part of the meeting. Now, they can't record it in a way that disrupts the meeting, but they can record it, including live stream, Facebook, and all the other things that they can do. Social media. So posting on social media doesn't constitute notice, and there are open meeting law decisions on that. I've cited some of them. Communications among board members on social media are subject to the open meeting law. There are decisions on that. You cannot communicate with each other about matters that are within your jurisdiction. If you want to communicate, hey, I had a bumper crop of tomatoes, who wants some? And somebody else on the board says, I'll take some, thank you. That's not within your jurisdiction, talking about your gardening. But anything within your jurisdiction, not on social media together, because even if you read it and don't comment on it, you've now got a deliberation. And remember that posts on social media by board members are matters within the jurisdiction of the board, may be subject to the public records law. That includes, by the way, your text messages and your personal emails. So in order to follow the open meeting law, you have to convene always. Even if you have executive session and there is nothing but taking a vote to go into executive session, there's no public comment, there's no review of minutes, there's nothing. You always have to start an open session. And then you have to make the motion for executive session. And I've cited the law there, it's 30A, section 21A, and then you have to include one or more of the purposes. So you always have to tell the public why you're going into executive session. And then you have to take a roll call vote. And the roll call vote is anytime you're going into executive session, and every motion that you make in executive session has to be by roll call vote. It has to be, even if it's unanimous, it has to be recorded by roll call vote. And the chair needs to, after the roll call vote, announce the purpose for the executive session and whether or not you will be reconvening in open session, so that people know. If you are doing this and there's any remote participation by any board member, or if you're all remote, then every motion, including those in open session, have to be by roll call vote. There are 10 permissible purposes for the executive session, and you can only go in for one of those 10 purposes or multiples of those 10 purposes, but you can't make up a purpose. So purpose one is the one that often we see, which is that you are going in to discuss an individual, a public officer, an employee, a staff member's reputation, their character, their physical condition, their mental health, discipline, dismissal, or complaints against them. The professional competence of someone is always open session. It's the executive session is the reputation, character, and physical condition, all of those that I listed. The employee, however, or the individual who's the subject of this, can always request that be held in open session, and then you must hold it in open session. If you do hold it in executive session, that individual has the right to 48 hours notice, not just the posting notice, but individual notice to that individual. To be present, they have the right to be present, to bring their attorney, to speak on their own behalf, to make an independent record, which means in executive session they can record it, or they can have an audio recording or a transcription. They can bring a court reporter if they want. Their legal counsel, we often refer to them as the potted plant. They can sit next to the individual and they can whisper in their ear if they'd like, but they're not supposed to participate. They're there to advise the individual only, not to advocate on their behalf. There are a number of other purposes. Oftentimes we go in for strategy sessions in preparation for negotiations with non-unionized personnel. You would do this when you were going to go do a contract negotiations with your town administrator, for example, or your police chiefs. You would do this also if you're going to conduct collective bargaining, if you're bargaining with your police union or your fire union. You would discuss, for purpose 3, to discuss strategy with respect to collective bargaining, so preparing for collective bargaining, or litigation. And that's if an open session would have a detrimental effect on your bargaining or litigating position, and you have to say this. So the minutes need to include that statement by the chair that the bargaining or the litigating position may have a detrimental effect if it were held in open session. If you were going to talk about security personnel or devices, obviously that would defeat the security if it was an open session. So you would go into executive session for purpose 4. Purpose 5 is to investigate charges of criminal misconduct or consider filing criminal complaints. That doesn't usually happen with the select board, but it can. To consider the purchase and exchange or lease of value of real property. If you were selling property, if you were buying property, leasing it, all of that would be done in executive session. Number 7 comes up a lot because your executive session minutes are reviewed under purpose 7, which is to comply with any general law, special law, or federal grant and aid requirement. So every time you review an executive session minutes, they would be under purpose 7, and you are required to list the minutes that you are going to be reviewing and approving. And then you can decide under purpose 7, when you're there, are the minutes accurate? Yes, we're going to approve them. Are they going to be released? And if they are, then you'll have to announce that at your next open session. But if not, then they stay privileged.
Liz,
There
can
are-
I just ask
yeah.
a quick question on that?
Sure.
Purpose 7 covers you completely, or do you also need to list the purpose under which those minutes were originally taken? Meaning if it's under purpose 2
No,
or purpose 3?
No,
Okay.
just purpose 7 if it's just review of the minutes, it's under purpose 7, and you must list the actual dates of the meetings. So if you had, 5 of them or so, you list all 5.
Got it.
And then I'm not going to go through every one of these, but you can interview candidates, but only up until a preliminary screening committee. So once you've made the cut, then finalists are done in open session. To meet with a mediator, this excludes labor mediation with respect to litigation. And then to discuss trade secrets. I don't know how many trade secrets most of our municipalities have, but if you had any trade secrets, you could go in there to for executive session. The deliberations in executive session are confidential and they cannot be disclosed until the actual board decides to approve and release the executive session minutes. And so if the board doesn't, and any board member were to release confidential information, that would be a violation of the state ethics law, which is 268A. We all take that online test every 2 years. And I know people just kind of click through it, but there are some really significant, we're going to talk about that in a little while, significant penalties for violation of the state ethics laws. So we want to make sure that nobody discloses it to anyone. Okay. The minutes of your open and your executive session need to be separate. Minutes, open session minutes, executive session minutes. They always have to include the date, time, and location of the meeting. If it was virtual, then it was virtual. The members who were present and absent, all the documents used at the meeting, because those are part of the session minutes. A discussion and a summary of each and every topic that was discussed. Now, if you have something on the agenda that wasn't discussed, you could list it and say it was not discussed. We did not deliberate on this agenda item, because people can take the posting and they take your minutes and they say, well, look, there are 3 things on this posting that are not addressed in your minutes. Your minutes might not be accurate, but in fact, if you note them and say no deliberation was had on this item, or we didn't do this item, it helps so that later on, months later, when someone's asking about it, that it's something you didn't talk about. Every motion that's made, every vote that's taken. And remember, the votes have to be by roll call if there's any virtual participants. And in executive session, every vote is by roll call. You approve all minutes within the next 3 meetings or 30 days, whichever is later. This requirement applies to open and executive session minutes. I know that a lot of our boards just sort of let those executive session minutes sit there for a really long time. You really need to do that. And if you haven't done it, it's time to catch up. Periodically review those executive session minutes, even if they've already been approved, to see whether or not they can be released. And you determine whether continued non-disclosure is warranted. For example, collective bargaining strategy might be strategy you'll use the same strategy the next time you're in bargaining, so you may not want to ever release those because that would disclose your strategy. The union does not open up its playbook for us to see, and I think that kind of makes sense. If there's attorney-client privileged information, then you certainly wouldn't want to release that. So those are the kinds of things you would be looking for. If the board decides to release its executive session minutes, you have to announce this decision at the next open session meeting and include the announcement in the minutes of that meeting. And that, I mean, in the open session part, because people may want to ask for them, but they wouldn't know that they were released unless you announced it. And the law does require us to do that.
So,
Requests
Liz,
for
sorry,
open-
I'm interrupting you again.
No, keep interrupting because I can't see you. So go ahead and tell me when you have questions.
So if the board decides to release them, it's just an announcement in open session. It's not a vote.
Well, you've already voted it in executive session.
Right. But you do not.
So you
do
just
not have to
announce it in
release
open session, and then open session meeting where you announce it, those minutes include that.
Got it.
And it's just really the dates. If it's really the dates of those meetings.
Okay.
Requests for minutes are interesting because you have to provide a copy to the requester within 10 days, and it doesn't say 10 business days. It's not the public records. Whether or not they're approved or in draft form. So if you're releasing them and they haven't yet been approved, make sure they've got a big draft watermark across them. Executive session minutes, if someone has requested them and they haven't been reviewed, then you have to review them at the next meeting, notify the requester within 10 days of the request. The board needs to review them, and after the review, notify the requester of the outcome. We've reviewed them, but we're not releasing them at this time, for example. Meeting notes. The minutes of any open session, the notes, recordings, and any other materials used in the preparation of those minutes, and all those documents and exhibits that were used at the session are public records. So I'm not talking about your little memory aids that you write down, but any minutes that are being taken, even in draft form, are part of the public records. Any documents you look at, any letters that are submitted to you, anything that you read and reference at an open meeting is part of the open meeting minutes, and you need to keep it with them. Anything that, the way that Attorney General has looked at it, it's used at a meeting when it's physically present, verbally identified, somebody mentions it, and its contents are discussed by members of the public body during an open session. So if you do that, it's a public record. Texting and emailing, this is really, I wouldn't say I don't call it the old days, but back before we all had cell phones and before they actually did texting and emailing, if you needed to, tell your family you were going to be home late, or the babysitter, the meeting is going longer, you'd ask for a momentary recess, or you'd step out of the room for a moment and make a phone call, usually by putting a dime into a phone and calling. Now people are texting, I'll be late, or I didn't get milk on my way home, or whatever it is. And you're doing this and the public can see that. But they don't know that you're texting, good night, kids, love you. I'm going to be late. I'll see you in the morning when you wake up. Instead, they think that, Chris is texting Scott about what she thinks we should do on the vote. And Peg is saying, oh, no, I disagree. And you're all having a private meeting during the open meeting. And nobody knows this because they don't know that you're all saying it's going to run late tonight, or, gee, the weather's getting bad. Can you come pick me up instead of me walking home? Whatever it is, don't be doing it in an open session or even an executive session. People are requesting, as part of the public records, every text message that occurs at a public meeting, every email that occurs during a public meeting, that time period of every member. The public records requests are coming in for that. And even if it's on your personal cell phone, if you're doing it during a meeting, you're going to have to turn it over and we're going to have to go through it. I don't want to look at your phone, your private phone. I don't want you to have to find your text messages during that time period. I can promise you, you don't want the whole world seeing your messages. So don't do it. Like, no texting, no emailing during that period of time, so that we can say we looked and there were no emails. There were no text messages. Oh, did you see Liz looking at her phone during the meeting? Oh, no, she was just checking the time. There were no messages received, no messages sent. And if someone is sending you a message, unless you happen to notice it's your kid and they're saying, I've had an accident, don't look at it, don't read it, don't do anything, because it looks like even if it's not among the board members, it can be from the public to you. That looks like a public comment during a session where you're supposed to be deliberating with the board member.
So Liz, my
Yes.
job requires me to be available 24/7. And there are definitely times during board meetings where I am on call and responding to technical and other emergencies that happen at work. How would you address that? Because I don't want to just skip those meetings in the off chance something happens, because I get those messages. I look at them like, oh, this can wait till after the meeting, or somebody's going to text back, I'll get you in an hour.
I would
What is the
say
best
that
way
it would
to-
be best to step out of the room for a moment, excuse yourself for a moment, go out into the hallway, take care of your personal business, and come back in.
Yeah, but some of it is that, like, I'm looking at the IT ticketing system. I don't even know there's something there because I don't get a notice every time something comes in. And so if I have to excuse myself every 15 or 20 minutes out of that meeting, it's going to be incredibly disruptive. And again, I don't want to skip these meetings.
Are you on call at the time every day, or is this sort of a rotation?
When I'm on every 9 weeks, I'm on call for 24/7 for 7 days. And even when I'm not the on-call person, I run the department. And so I'm backing up the person who is on call. And so when I'm not on call, I'm not looking at it as often, but it is important for me to keep abreast. And I have no problem. I've been trying better to. I'm worried because I'd like to, like, I'll have the ticketing system up. I'll look at it. I'll set my phone down, unlock, so that other people could see that I'm not doing or delivering. But if I set it down so Chris can confirm that I'm not deliberating, then Chris is looking at my cell phone. And I think that is more problematic. And that, someone might say that Scott typed something that Chris could see that I'm going to delete as soon as it's done.
Well, I don't think Chris needs to see your cell phone, especially your work cell phone. I would
Right.
say that,
Well, I don't have a work cell phone. I use one phone for both work and personal stuff.
yeah. Well, you're going to have to do your best to try. I would say the best you can do is to try and schedule those weeks every 9 weeks, not be a week that you actually have to have a meeting if you can. And if that doesn't work, then the best you can is to try not to be looking at your phone or doing any email, because people can't tell unless you want to say,
Right.
Chair, I'm going to ask you for a moment. There's a work related, not related to the town of Berlin matter that I need to address right now. Please give me a minute to go do that. And people will know, okay, you've stepped away. No different than if, somebody says, oh my goodness, my child has just texted me that, I need to take this for just one moment and step away, right? So at least the public knows that it's not something within the board's jurisdiction, it's something else, and you can take a moment. Of course, if two of you are doing it at the same time, you've lost the quorum.
Right.
But to the best of your ability, no texting or emailing is certainly not between the public and you about board matters, and not between each other, among each other about board matters. At least if someone asked them, they can see that there was nothing that had to do with anything about board matters. All right, public comments, do's and don'ts. You have a public comment session in your meetings. There is a section in the law, chapter 30A, which is the open meeting law, section 20G is in George, that talks about no person shall address the meeting of a public body without permission of the chair, and all persons shall, at the request of the chair, be silent, and no person shall disrupt the proceedings of a meeting of a public body. And if after clear warning from the chair, a person continues to disrupt the proceedings, the chair may order that person to withdraw from the meeting. And if they don't, then the chair can authorize a constable or other officer to remove them. So the law doesn't exactly tell us what, it doesn't require us to have a public meeting, a public comments part of our meeting. But if you include one, then we have to follow the law, and we have some case law that came out not that long ago about public comment. So with the exception of executive session deliberations, the board must be open to the public, but the public doesn't have a right to speak anytime or participate anytime they want. So you really should establish a procedure for public participation. And this is everywhere in every board. Set a time limit for public comment if you are going to have it. 15 minutes seems to be a reasonable amount of time, but if you wanted a longer one, you could have a longer one. Set a time limit for each speaker. And you can't say, oh, this is not like I'm going to yield to the person behind so that person gets more time. Each speaker gets whatever it is, 3 minutes, 3 minutes. If I use 1 minute, we go to the next speaker. I would recommend certainly limiting the policy to have comments about matters on your agenda, or at least within your jurisdiction, and require that all speakers address the board through the chair, so that there's not a lot of back and forth or attacking of, I want to know what your town administrator says. Like, no, this is not an interrogation. It's just an opportunity to hear their comments. The law doesn't say what a disruption is, but I would say that it's pretty clear that if you have a member of the public who forcibly grabs the microphone from another speaker, that's a disruption. They've not been recognized. Or yelling while another person is speaking. Not necessarily when they're recognized, they can yell, but when someone else is speaking, they can't yell over them. Holding court when their time is up, they keep on talking. And it doesn't have to occur just during public comment time. It can occur at any time. No disruptions are allowed, and we really should enforce these. So there was a case called the Barron case, an SJC, and that's the number of the SJC case, talked about public comment. In Southborough, the select board's policy prohibited some disruptions. It said, and this is their actual policy: all remarks and dialogue in public meetings must be respectful and courteous, free of rude, personal, and slanderous remarks. Inappropriate language and or shouting will not be tolerated. Furthermore, no person may offer comment without permission of the chair, and all persons shall, at the request of the chair, be silent. No person shall disrupt the proceedings of a meeting. Well, during the public comment portion of a meeting, the commenter, the member of the public, was accusing the board of breaking the law, and after the chair objected and called it slander, because he was being accused of breaking the law, the member of the public who was speaking said, "You need to stop being a Hitler. You're a Hitler. I can say anything I want." The chair ended the session and the person brought a lawsuit. The relevant claim was brought under the Massachusetts Declaration of Rights, but that's pretty much the same as the US Constitution's First Amendment guarantees. So the Superior Court first found that it was a limited public forum, and because the board restricted it to town residents to address matters that were not on the board's agenda, they thought it, means that the board's policy needs to be reasonable and it needs to be neutral on viewpoints. Like, you can't shut down speakers because you don't like what they're saying, but let other speakers speak because you like what they're saying. Well, the Superior Court gave its decision, and then it was appealed again. And the SJC took it. And the Supreme Judicial Court found that the board's policy violated the Declaration of Rights, specifically that all remarks and dialogues in public meetings must be respectful and courteous, free of rude, personal, or slanderous remarks. Inappropriate language and or shouting will not be tolerated. They said that part violated the law, violated our Declaration of Rights. So the SJC found that discourteous, rude, and disrespectful or personal speech about government officials and government action is protected. In other words, the public can criticize its government leaders. And so it applied strict scrutiny, and it indicated that certain types of restrictions would not comport with this. And the reasonable time and place was fine. You could say, here's how much time you get. Here's what you can, here's so much time for public comment, so much time for each speaker. That's okay. The SJC also observed that in order to function efficiently, towns must be able to hold public meetings limited to a particular subject. And I actually would recommend that. I do recall, I'm just going to use my example. When I was on the school committee, we were talking about changing some bus things. We held a special meeting so that we could have a whole meeting to hear about it, because the whole public wanted to hear about it. All the parents were concerned about changing bus times. That was something that was important to everyone. We held a special meeting and had a hearing on it, just like you have hearings on your budgets. It did not address whether it was constitutional policy could bar slander, but frankly, it's unlikely that you would have proof of slander at the time the comment was made. So I don't know that that would be very helpful. The takeaways from the Barron decision: a commenter cannot be barred from engaging in disrespectful, rude, or personal speech directed at public officials. So if they want to come and be disrespectful or yell at you, we take it. Of course, you're going to take it for the 3 minutes or 2 minutes or whatever you decide is the amount of time that they can do. You can't treat speakers differently from each other based on their viewpoints. The person who's yelling at you that you're doing a terrible job can't be cut off, while the person who came to tell you, and they don't usually come, I would wish they did, to come and say thank you for your good work and we appreciate your service. But when they do, you can't let them have more minutes just because you like what they're saying, as much as you'd like to have them fill up the whole 15 minutes. The board or the committee can impose reasonable time limits for the entire public portion. The court didn't say how many was reasonable, but 10 to 15 minutes. You have important business to do, and the public can email you. They can send you a letter. They have lots of other ways to send their communications. And you could have a reasonable time for each speaker. We think 3 minutes would be reasonable. The court didn't make a comment on that, but that seems to be sort of the general amount. You can say a lot in 3 minutes. They can be barred from engaging in dialogue with the board and committee. Like, we don't have to respond to them. They can say what they want to say, and we move on to the next speaker. They can be barred from interrupting or interfering with other speakers. Speakers can be barred from engaging in physical conduct. You can't shove somebody out of the way. And
Liz, I think, Peg, did you have your hand up?
I do. I was just, oh, hang on.
No, now you're
Okay, there I am. All right. I was looking down, so I'm looking at the town report. And Liz, you've been talking a lot about boards and committees. And I'll take my hand down. Now, in the town bylaws governing the conduct of meeting, it talks about the moderator shall determine the bounds on the floor, where it talks about people coming up and talking. So I'm gonna assume that maybe we need to look at the town bylaws governing the code of conduct for town meetings so that we're all in alignment. Would that make sense?
Town meeting usually does, because this is about public comment at your board meetings. Town
Okay.
meeting, usually the moderator will recognize people to speak on certain warrant articles.
Right,
And that may be 2 or 3 minutes, that might be 5 minutes. Oftentimes, you know, there's presentations could be longer. Finance committee certainly
Right.
usually recognized repeatedly on every warrant article that has anything to do with money. So I think that's a little bit different.
okay,
But again, the moderator would stop speakers from interrupting each other. When the moderator recognizes the speaker, that speaker has the floor, usually till the speaker's done. Or
Right.
the moderator says, all right, we've heard you, you've repeated it 3 times, we're done. Move on to the next speaker.
okay.
But
All
yeah.
right. Awesome. Thanks, Liz. Appreciate it.
Okay, number 8, though, I think I didn't get to, which is any threats of violence can be shut down. So any threats of violence, you know, those things you don't have to listen to. The board or the committee should be able to limit a public comment session to specific topics that are either within their jurisdiction or matters that are on their posted agenda. And they can request that participants register or sign up in advance so that the public comment session can kind of go smoothly, as opposed to calling out, you know, you'll be next and you'll be next. Just have a list of who wants to speak. Okay, Peg's got her name up first. She goes first. Okay, Scott's next. The next, you know, Chris is after that. Liz is after that. You know, just take them in order. You can't ask them what they're going to say, but you can ask them to sign up so that at least you can call them in some kind of an orderly fashion. It did not address whether the board must include a public comment session in its open session meetings. The law doesn't require it. You might do it once a month. You might do it every single session. That's entirely up to each board. And there's always other ways. And I think every single website I've seen of every community has a way to communicate to a board through email or written communication. Again, as I mentioned before, this slander and the Barron decision, the court left open whether slander is an act that you can stop someone for. But again, slander is something that has to be determined by a court. So it's kind of hard to say that somebody could come and we know it was slander at the time that they were making the comment. And even if a comment is false, it usually has to be made with actual malice when it's against a public official. In other words, public officials are meant to have to shoulder a lot more than just anybody under the First Amendment. SJC did not address whether you could have a policy barring the use of obscene or profane language. You know, I have found that sometimes when we let the public say whatever it is they want, the way they want to say it, and we just move on without a whole lot of reaction, it's pretty good. And then, you know, all of these things are recorded. And so when they run for some office, these things seem to come back and haunt them. And then people know exactly what they're getting. Okay. So remember, the board cannot apply rules based on content or viewpoint of the commenters. So whatever your viewpoint is, you can't say, oh, we like this, you want to support X, and we are in favor of X, so therefore we're going to let you talk longer than the person who is opposed to X. Cannot do that.
Can I just ask one thing,
Yeah.
Liz? When someone wants to address the board and that I think we all get very passionate, you know, about certain things, especially when someone comes to the meeting and wants to talk about it. I think we all have to remember too that not to, you know, bicker back and forth with the person.
Exactly.
And I think you've mentioned that, haven't
I
you?
did. Yeah, not going back and forth, not interrogating, not expecting a response. If it's something the board thinks there should be a response to or discussion, then put it on the agenda for another meeting.
Right.
And you can deliberate then. But it shouldn't be like, if people have questions, they should know ahead of time that you're not going to be responding, or you're not going to be grilling the town administrator, for example, because that's never looks good, right? Here, we've got a bunch of questions we'd like the town administrator to answer right now. And here they are. We're just going to blindside her. Same thing with the chair of the select board. We'd like to have all those questions answered right now. Why? You're saying silent? Why aren't you speaking? We told you at the beginning, we just move on. We take one.
Thank you very
speaker.
much.
I don't, well, you can say thank you. I don't always like to say thank you, because if you say thank you to the ones you like and you don't say thank you to the ones you don't like, that doesn't work so well. So I just say next speaker.
Mm.
Your time is up. Next speaker. You can say it nicely, but that's because if you say thank you very much, you may be saying thank you very much to something you really don't want to say thank you very much to.
Well, Liz, and also, I mean, I don't always mind being put on the spot, but my concern is getting into a discussion of something that's not on the agenda.
Well, yes, plus it's not on the agenda, but also then it becomes an expectation that someone is going to respond to them that night. Public comment is to receive, not to respond. I think that's the way, and you have to, but you have to be consistent with it, because if you respond to some and not to others, then you're inconsistent. So have a clear written policy setting time, place, and manner restrictions. So how much does each speaker get to speak? How long can, will the whole public comment section last? And it usually puts a limit, 15 minutes or to the last speaker has had their time, whichever comes first.
We always have a very lively public comment period. It usually entails no one. We try to get June to say something once in a while, but she's in the back and she won't say anything.
Well, that's probably because your public must believe that you're doing a good job, because if they were unhappy, they'd come and tell you about it. But like I said, they don't usually come to public comment to say thank you, although I wish they would sometimes, because it is a volunteer job that you donate a lot of time, energy, and effort to, and it would be nice for people to sometimes acknowledge that.
Right.
And again, you only place limits on it to have an orderly process. Prohibit obvious acts of disruption. Do not limit any speaker based on the content or viewpoint of their speech. The focus should be on disruption. So if it's not disruption, just because it's controversial doesn't mean you stop them. Apply the rules consistently. If one speaker engages in conduct that causes the chair to issue a warning or to cut the speaker off, and another speaker does the same thing, they get the same reaction. And unlike baseball, open meeting law only gives you 2 strikes. The first strike, the chair gives you a warning. The second strike, the public commenter can be ordered to withdraw. And if that doesn't happen, you might have to take a brief moment to get somebody, because you probably don't have anybody there who can require them to leave, but the police are not very far away. So I think you could get them to come upstairs and remove the person.
So, Liz, if you have, for example, someone who's just repeatedly yelling out from the audience during, it's not their time, they haven't been recognized by the chair can issue a warning, and then the second time they can ask that they be removed.
Yes.
That they leave.
Yes. You've yelled out, you need to be silent. You need to be silent. You're not being silent. You call the person, you may have to call a police officer to remove them. You 3 and the town administrator are not going to personally remove them. That is a job for a constable or a police officer. But as the police are not too far away, so I think we could get somebody to come up and help you with that. So we have a couple of exercises. The best select board meeting usually starts at 7 and has been lasting until about midnight because of the public comment portion of the meeting, which has been placed as one of the first items on the agenda, and it's been hours long at each session. This has resulted in the best select board not starting its business until 9 p.m. or later. Board members are tired by this time, and by the time they get to the board's business, and often much of the business requiring deliberation of votes is delayed to future meetings because members need to leave before the business is completed, resulting in the quorum being lost. What are some options the board can take to address this?
You want suggestions?
I do.
Oh,
No, I think we could remove the public comment period.
You can. What else can you do? You can have a shorter public comment period. Don't have to let everybody come and speak. You can shorten you can limit it to 10, 15 minutes. You can limit how long people can speak for, say 3 minutes and no more. You can limit it to items on the agenda. So can the board limit the amount of time to the agenda for public comment? Yes. Can the board limit the amount of time each recognized speaker has? Absolutely. Can the board restrict the comments to items in the board's jurisdiction? Let's hope so, because you don't want to hear about everything else. Can the board restrict the comments to items related to matters listed on the board's agenda? It can. Can you restrict participation to individuals who reside and work in the municipality? I think you probably can. We've been seeing a lot of people coming from the Midwest telling us what books we should not have in our libraries. I'm not sure we care what they think we should have in our libraries. These are our libraries. Can the board schedule a separate meeting for public comment and matters about which there may be lots of interest in the public? And absolutely, you can do all of those things. Lawrence Loud interruptions. The best board has a policy that permits members of the public to speak for 3 minutes during the portion of the board's open meeting set aside for public comment. Individuals wishing to be recognized sign up to speak. The chair has always called them in order on the list. On April 22nd, Chair Empire got to the public comment portion of the agenda and called the first 3 speakers in order. The chair inadvertently skipped the 4th speaker and recognized the 5th speaker. As the 5th speaker began to make his comments, the 4th speaker, Lawrence Loud, interrupted him and demanded to be heard next. What should the chair do?
Scott, you have your hand up.
Yeah, but it's going back to the last one, so we'll do that when we're done on this.
Okay, what do you think we should do?
I think you could recognize the 4th speaker, or at least make sure there's enough time for the 4th speaker after the 5th speaker is spoken. In other words, you don't want the clock to run out.
But you could certainly say, you weren't recognized, Mr. Loud, sit, because we've got the other person who was already recognized. So after the chair directed Mr. Loud to be silent, Mr. Loud went to the microphone and grabbed it from the speaker whom the chair had recognized to speak. Now what does the chair do?
Get someone to take him out.
Yeah, that's a disruption. What if Chair Empire didn't inadvertently skip Mr. Loud, but did so intentionally and at multiple meetings because Mr. Loud has been critical in the local newspaper and on social media about the board's budget? Do we have a problem here?
Yes.
Yeah, now we have a problem because it's based on the content of his speech as opposed to, gee, I inadvertently did it. I mean, I've got a list, but sometimes I mess up.
Mhm.
You wanted to say something, Scott?
Just back on a public comment. So outside of a public comment period, we're discussing something that's on an agenda, and there's someone in the audience who wishes to comment on it. What is like we and it might even be someone who we would like to hear from, because like, oh, we're discussing, I don't know the topic. I don't want to give an example that is real. But that there's someone in the audience who we know has expertise in that topic or is particularly interested in that topic. How do we recognize them without necessarily opening up a conversation among everybody in the audience about that topic?
I would say that if you anticipate that you would like to hear from a person who has some expertise, you might put on the agenda that we also would be hearing from, person X who has some expertise in this area. And that way the public knows it's not a public comment free-for-all, it's just on the agenda. But generally you should follow Robert's rules, and you are all elected to use your judgment. But if you need the sort of input or advice or counsel of someone else, then you could ask for that, and that could be part of what you're planning to do. I see we've invited Liz here tonight because we want to ask her about this particular issue on the wells. And she's a water expert or something. And so we're going to get some input from her. Okay, she comes in and she makes her input, as opposed to, oh, I see Liz is in the audience and I think she knows something about wells. Let's ask her what her opinion is, because then everybody wants to talk and they all have an opinion.
Right. Yeah, sometimes, and so I'll give I think I can give this example out crossing opening, but that like we're discussing budgets, and among the board members we're having a conversation, and the chair of FinCom happens to be in the audience. We didn't invite them, they happen to be there, they raised their hand politely, so they're not interrupting anything going on. The chair does have the authority to say, I think someone in the audience who's raised their hand and
I wouldn't say
has
someone in the
something to say on
audience.
this we'd like to hear.
I noticed
I'm
the
gonna
chair
ask-
is I wouldn't say someone in the audience
The
because it's not just someone, it's the chair
Yep.
of the FinCom who actually
Right,
had
right.
lots of meetings about this and may be able to shed some light on our questions, certainly.
Right.
Okay, Francine Fire, during a public
And then
comment,
we can do that and then ignore random person X. Okay, yep.
Yeah.
Never mind.
during public comment at the Best Select Board's meeting on April 22nd, Francine Fire was recognized to speak by the chair. Fran started off by saying the following: "You don't know what you're doing. You're failing our seniors with your tax increases and you don't care. It's as if our town is on fire and you're taking your time calling the fire department. I pay taxes here, so you all work for me. You should all be impeached. But until then, I know where each of you lives, and don't be surprised if you wake up one morning and find your house on fire. You all better watch your backs when you leave tonight." Okay, Francine was about to continue speaking as her 3 minutes were not yet up when Chair Empire took action. What did the chair do?
Had her removed for threats of violence.
Yeah, that's a disruption. That's a threat. That's no way. And in fact, at that point, you're calling the police because you actually have got threats of arson at your homes. Dan Disruptor, the Best Select Board started open session meeting at the posted time at 6 o'clock. The first item on the agenda after approval of the minutes was public comment, which by policy is not to exceed 15 minutes. Public comment started at 6:20, but there were only 2 persons who were present to speak. When they completed their statements and no one else asked to speak, Chair Empire ended the public comment section and moved to the next item on the agenda at 6:26. Dan Disruptor arrived at the meeting at 6:30 and noticed that the committee was on the next agenda item after public comment. He shouted at the chair saying, "Public comment isn't over. I want to speak now. You have to let me speak. I have a right to be heard." What should Chair Empire do?
Would they be obligated to let Dan Disruptor speak?
Nope,
No, I don't think so. It says
Nope.
up to 15 minutes, not will be 15 minutes.
exactly. Otherwise, you just sit there for the 15 minutes hoping that somebody would show up. No, you tell Dan Disruptor, be seated, be silent, be silent. If he's not silent, after one clear warning, out he goes. Next time, he's out. If he wanted to be there, he should have been there at the beginning of the meeting. Remember, meetings, if you put time periods on there, it may not start exactly at the time. Might start earlier, might start later. You don't know. But once it's over, it's over. You're not there, you can't speak. BAT demonstration. The Best School Committee and the Best Association of Teachers, BAT, have been engaged in negotiations for a new contract. BAT wants more money and fully paid parental leave for up to 60 days. BAT directed its members to storm the Best Select Board's meeting with their signs and chant "More money for teachers." At the Best Select Board meeting on Thursday, 200 BAT and MTA members carrying large signs marched into the meeting that was already underway, interrupted the town administrator's report, and chanted "More funds for schools, more money for teachers." What should the Best Board chair do?
Well, that's clearly a disruption.
It sure is. So it's a warning and a removal.
Right.
Okay. Paul's Pizzeria. Paul has been working for years on his recipe for the perfect pizza and opened his own pizza shop down the street from Best Town Hall. He is excited to let the community know about his menu and pricing, but after paying rent, leasing pizza ovens, and paying for employees, he has no budget for marketing. At the Best Select Board meeting on Thursday evening, Paul signs up for public comment. When Chair Empire recognizes him to speak, Paul introduces himself and then starts reading from his menu, including the descriptions of his amazing pizzas and the prices. Paul has practiced so that he can get through the menu in just under 3 minutes, the time permitted for each speaker. What should Chair Empire do?
Just
Well,
stop it. It's not on the agenda.
If you have a policy that it's not on the agenda, yes, you can stop him. Is it within your jurisdiction to listen to a pizza menu?
So,
You know,
Not.
I'm
It's
wondering,
No,
wondering
yeah.
what would we do? What would we do?
Order,
Let them.
place an order,
Place it
Yeah,
on.
say,
There
wait
you
out.
go.
place an order.
All right, well, that wasn't the answer I was expecting, but some additional notes. Committees are not required to have a public comment session at each meeting. They can consider the length of the public comment session and the placement on the agenda, anticipate disruptions and be prepared, and always apply restrictions on public comment uniformly and without regard to viewpoint or identity of the speaker. We love her. I know she's a little old lady. She comes to our public comment and she starts talking about the garden that, she'd like to create or something that's not within our jurisdiction, so we don't talk about it. It's if you either have a free for all and you can say anything you want in 3 minutes, or you limit it to what's within your jurisdiction. And I think you should review and revise your policy to comply with this SJC Barron decision. Open meeting law complaints. Complaints have to be filed with the board chair within 30 days of an alleged violation. You have 14 business days to meet to review the complaint and draft a response and explain why there was no violation, or if there was a violation, well, remediate it. Send a response to the complainant with a copy to the AG's office, and you have no obligation to respond to complaints that are anonymous, unsigned, or that are not filed on the AG's complaint form. And the chair must ask the complainant for more. You could ask the complainant for more information if they said, hey, you violated the law last month, but they didn't identify how you violated or which meeting, so you wouldn't be able to respond. You could ask for more information. And then if you're not satisfied, if the complainant's not satisfied with, they can file with the AG if they don't like your answer. If the public body is found to have violated the open meeting law, the AG can issue an order to compel immediate and future compliance, compel attendance at a training session, but you could show them these slides and say that, oh, we did attend this. Nullify in whole or in part any action taken at the meeting. This has happened when, if you, let's say you improperly terminated somebody and didn't give them the notice, they could nullify that, or same thing with hiring somebody. Impose a civil penalty upon the public body of not more than $1,000 for each intentional violation. Reinstate an employee without loss of compensation, seniority, tenure, or other benefits if you did it outside of the open meeting law. Compel that the minutes and the records or other materials be made public, and any other appropriate action. If you get the frequent flyer of the open meeting law complaints, if a complainant files 5 open meeting law complaints with the board within a 12-month period, the board can request mediation with the complainant prior to or with its response to the 5th complaint. Mediation is at the public body's expense. You'd have to pay for it, and the mediator is selected by the Attorney General. I think it's an effort to stop the repeated complainants. It can be held in open or in executive session, or and you can designate a representative to participate on behalf of the board. It would likely be your town administrator and your attorney. And a complainant's refusal to participate in mediation allows the AG to decline to review the complaint. This is for the frequent flyers. I don't believe you have any frequent flyers at this time. You are a member of the Best Select Board. You are at home scrolling through your Facebook newsfeed, and you see that the town administrator is a finalist for the town manager position in a town of good. The Select Board is not scheduled to meet for another 2 weeks, and the board doesn't want to lose its town administrator. Can the board call for an emergency meeting the next morning? Yes or no?
And have the meeting the next morning? No.
That's correct. They cannot. What can the board do?
You have to give 48 hours notice.
Exactly. The blizzard that closed Town Hall, a terrible snowstorm, has left Town Hall closed and without power for several days. The Select Board has a very important meeting scheduled this week, but no one can get to Town Hall to see the agenda or onto the Town Hall website calendar to view it electronically. I guess you're all without power and without internet. Can the board members post the agenda for the meeting on their Facebook or Twitter accounts?
No.
Well, they could post them there, but does that satisfy the posting requirements?
No.
No. The blizzard, same blizzard, a terrible snowstorms. You've lost the town hall is closed, the power's gone, everything's bad. The pipes froze and the floor is flooded. The town does not have employees available to fix the pipes or clean up the flooding, and there's concern that if they leave everything wet, they will have mold. The Select Board does not have a meeting scheduled for 1 week. What can the Select Board do?
Grab a mop and clean.
Oh, I guess you could do that, but let's say you don't want it. I mean, you are volunteers, but that is going above and beyond, Peg. I think we have to think a little bit bigger than that. You can hold an
We
emergency
could meet
meeting.
together.
Yeah.
And you can hire somebody, professionals to come in and do the cleanup and dry it out so that you don't have mold. That's the definition of an emergency.
Right.
The Google Doc. Oh, this one comes up. Do you guys use Google Docs?
Yes.
Oh, well, then it may come up. I did not know. Ms. Gala is a member of the Best Select Board. She received an invitation to edit a Google Doc with a draft policy on public comment from the chair of the board, Empire. Mr. Empire said that he is distributing materials for the next board meeting. Ms. Gala clicks on the link to the Google Doc and sees that Mr. Empire and the remaining board member, Mr. Baldwin, are making real-time edits to the document. What should Ms. Gala do?
Get off the site.
Get off the site. And what are the issues with the Google Doc right now?
It's deliberation.
Absolutely. It is a violation of the open meeting law. You cannot do this. And Google Docs make it so easy to do. Social media posts and reactions. The Best Select Board has 3 members. Member Gala has been posting information about the board's open session meetings on her personal social media page, which is set to public so anyone can view her posts. She often includes topics that will be addressed at a future board meeting, along with her opinions on these topics. She invites the public to weigh in and respond. She recently posted about a plan for the DPW garage. Board member Baldwin responded with a thumbs up. Board chair Empire responded with a thumbs down. Any open meeting law issues here?
Yeah.
Yeah, you just had an open
Mhm.
meeting law violation.
Right.
You just had a deliberation. Thumbs up and thumbs down have already been determined to be a deliberation.
I think the 3 of us are pretty good because even when Peg, you post, the coffee talk is coming up, Chris and I don't even thumbs up the announcement that there's a coffee talk coming up. I think we stay off of, I mean, I might see it, but I mean, I make no commentary on anything that you folks have posted. I don't think you folks ever comment on anything I have posted.
Even
I
if
think we're
you
pretty
don't
good about
comment and you read each other's, if it's more than just a scheduling thing, hey, this is going to be on the agenda, that's fine. You've read it. Everybody knows it's on the agenda. But if you're saying, my opinion is that we should not do I think we had DPW garage. We can live with the DPW garage the way it is. Well, if you read that, you've now got her opinion. So now you've got 2 out of the 3, you've got a deliberation.
Yeah, no, these lists are more like we do have a coffee talk coming up in a couple days. So obviously to try and get the word out, it's, hey, what are you doing on Thursday at 6:30? Come join us for coffee talk. We're going to talk about the warrant and the budget. Love to see you in person. Here's a hyperlink. See you then. Have a great week. So it's
Scheduling is
very,
fine.
yeah, it's very generic. It's not, oh, this is horrible and we need to vote it down.
Well,
It's,
and
come on.
any opinion on a matter that's within your jurisdiction that somebody else reads on your social media would be 2 people reading it is a quorum. All right, during an open session meeting, the Best Select Board members, Gala and Baldwin, are texting each other about how they plan to vote on an upcoming agenda item. Any issues here?
Yes.
Yep, they're having a secret meeting during an open meeting. Big problem. Chair Empire is receiving and reviewing text messages from the president of a local citizens group who is attending the select board meeting and who is making suggestions via text for motions. During the same meeting, member Gala is receiving emails and text messages from Neighbors for Neighbors, a local advocacy group whose members are watching the meeting live from the neighborhood house party. Any open meeting law issues here? What are they?
Public anymore.
We lost some of that, Kristen.
Oh, I just said it's not public anymore. It's not happening in public.
Right, but so they're reviewing the text messages during a meeting. You've got someone communicating to you privately during the meeting. That's not allowed. And you have someone else communicating who's virtual watching it and communicating to people on the meeting. Also not allowed. Total violations of the open meeting law. So remember to use town email accounts for all board matters. Use your personal email for your personal matters. You all, I assume, have town email accounts. Do not email, text, or use social media, etc. during open or executive session meetings. I understand you're going to have some challenges with that, Scott, but do the best you can. And do not deliberate outside of a meeting. Any questions before we go on to state ethics?
Okay,
Um,
go ahead, Scott.
Sorry, Chris. Any issues? So at the public meeting of the select board, I have my laptop open and we're talking about, I don't know, highway barn repairs, and I'm Googling sites to just try to gather more information on that topic. Is that going to be a problem?
I would say you should Google those sites before you come to the meeting. And come with your suggestions and deliberations. If you're going to Google the sites, you should just Google them up on the screen so everybody can see them. Just don't do it privately, because it's going to look like you're doing something and communicating. You're typing as you're Googling, it's going to look like you and somebody else is doing that. The two or three of you are doing it. It looks like you're having a private meeting. The public can't tell because they can't see your screen. Display your screen and everybody can see. Let's Google and see what comes up.
I just like to be informed of things, and things come up at meetings. The highway department's presenting something and says this is a $10,000 item. I didn't know that's necessarily coming up. I don't want to necessarily vote on something or even question something when it could be a simple answer.
Okay, it's possible, but the $10,000 item, unless they're buying it off of the state bid list, then it's got to go out to bid anyway. So you wouldn't be voting on it unless there was a bid and there's been a review of the submitted bids, or they bought it off of the state list. So, and then we know that it was already bidded. So I wouldn't worry about that. Okay, we only have about 20 minutes left because I know you have an 8 o'clock. So we have a lot of slides to go through. State ethics law, we're going to kind of gallop through this a bit. I know you take it every 2 years, but everybody forgets about it. So Massachusetts conflict of interest law governs the conduct of public officials, including board members and public employees. It ensures that private and financial interests and relationships of board members do not conflict with their official responsibilities. So how many of you get paid to do what you do? On board members, not Kristen, we know you're an employee, but,
Okay.
right? A little bit, right?
Yeah.
You can actually get fined much more than you ever get paid. So you want to be real careful on this. 268A is the state ethics law. It prevents conflicts between private interests and the public duties, fosters integrity, and promotes public trust. Well, it wants to make sure that you don't have a financial interest in things or that there's a conflict that would cause you to take action that would not be in the public's best interest. And the State Ethics Commission frequently fines. If you violate a State Ethics Commission, you will be required to pay restitution. Whatever you gained goes back, and oftentimes a penalty. So advertising your privately owned business at the workplace, $3,000 penalty, doesn't include restitution. Accepting a bribe to rig a bid, $4,000 penalty, doesn't mention what the restitution is. That's an addition, just a penalty. Participating in matters involving a family-owned business, $6,000 penalty. Nobody gets paid enough to do this, to make these kinds of errors. Approving payments for subcontractor family members, $7,500 penalty. Hiring your spouse as an assistant, that was a particularly egregious one, $25,000 penalty. Approving contracts for a company while negotiating employment with the company, $30,000 penalty. So I brought those up just so that you don't remember that this is serious. And since I spent 6 years, got paid nothing on my school committee for 6 years, and actually had to pay babysitters for the 6 years I was on. So it cost me money. The last thing you want to do is violate the State Ethics Commission ethics laws and then have a penalty that far exceeds anything you're going to gain. So they can impose civil penalties up to $10,000 for each violation you commit and $25,000 if it involves bribery. It can require you, in order to repay any economic advantage you gained. So that's the restitution. The penalty is separate from the restitution. And it can order you to pay back third parties injured by your conduct. So that big rigging, if another party lost money because of not getting the bid that they should have gotten, that could be thousands and thousands, tens of thousands of dollars. It also can refer you for criminal prosecution. So the State Ethics Commission enforces the state ethics law. They receive and investigate complaints, and those complaints can be anonymous. They have an investigation procedure. The commission receives a complaint. The Enforcement Division will review it. And then if the investigation is warranted, the commission formally investigates and determines if there's reasonable cause to believe that a conflict of interest of the law has been violated. Whoops, wrong direction, excuse me. If the commission finds a conflict of interest law has been violated, they can require a confidential education letter. That's the minor slap on the hand. You get it, nobody else sees it. A public education letter where your name and the whole world can read this and their decisions, and a disposition agreement, which is sometimes you pay X and it's resolved. If they find no violation, the case is closed and remains confidential. It addresses self-dealing and nepotism, bribery, gifts and gratuities, misuse of a position, false claims, confidential information. That's the one I told you about, disclosing of executive session materials. That is the confidential information that applies to you. Appearance of conflict, second positions, and leaving municipal employment. The self-dealing and nepotism. You cannot participate in any town matter in which you, your immediate family, or your business has a financial interest. Immediate family means you, your spouse, your children, your parents, your brothers and sisters, and the children, parents, brothers, and sisters of your spouse. Self-dealing, a board member cannot take any type of official action that will affect the member's financial interest or the financial interest of the board member's business partner, a prospective employer or business associate, and any business organization for which the member serves as an officer, director, trustee, or employee, and any member of the board member's immediate family. Remember, immediate family is your spouse, your parents, your siblings, your children, and your spouse's parents, siblings, children. Sometimes their children are not your children, but it applies to their children as well. You may not participate in a town matter involving an individual or organization with whom you are negotiating future employment. If you or your family or your business has a financial interest in the matter, you may not participate. That means if your brother owns a company that submits a bid in response to a request for proposals, you can't participate in awarding that bid. Oops. Okay, you are part of the team that reviews and selects bid for the town projects. Your son works for Great Construction Company, GCC. GCC submitted a response to the town's request for proposals, and if the town accepts the bid, your son is guaranteed to work on the project. Can you participate in the review of the responses if you do not vote? I'm seeing heads shaking no, that's correct. You cannot. May you review all the responses except the one from GCC? No.
No.
Can you participate in the selection? Absolutely not.
No.
All no's. Board members are prohibited from hiring, promoting, supervising, or otherwise participating in the employment of any person in your member's immediate family or in the immediate family of the member's spouse. Finances and gifts prohibits you from requesting or accepting anything without regard to what the value is in exchange for agreeing to perform or not perform an official act. And requesting or accepting anything of substantial value, which is $50, hasn't changed in decades, for the performance or influence of any official act within the duty of the member. So if it's in exchange for actually agreeing to perform or not perform something, it doesn't matter how much it is. It could be 10 cents. If it's for accepting anything of substantial value for your performance or influence, it can't be more than $50. Gifts worth less than $50 are not considered substantial. Ceremonial gifts. So after you spend many years on a select board, sometimes people give you a plaque. It's a ceremonial gift. It may cost $55 for all I know, but it has no value to anybody else. And gifts for family or friendship. So if your neighbor has always given you a gift at Christmas time, the neighbor can still, and you've done that, and you become a select board member, you can still accept the gift. Those are gifts of family and friends. Now, if the neighbor says, but if you make sure that my trash gets picked up first every Wednesday, that will, my gift is still coming. If there's something that you're tagging with the gift, then you can never accept it. Gifts to board members and guests. If the gift is less than $50 for the member, but would be more than 50 when the member's spouse or guest is also included, the total gift exceeds the substantial value. Scarce tickets. This came up, if you can all remember, way back when the Red Sox were actually in the World Series and the tickets were going for $4,000. If the face value of the ticket is 40, but the donor actually paid 400 or 4,000, if you remember that, you get the actual value that would be assessed. Aggregate value. If you get gifts all the time from a single donor, the recipient, the gifts are aggregated. So a cup of coffee every week could add up if it's Starbucks, I guess. Discounts. The commission has interpreted discounts of $50 or more to also constitute a gift or a gratuity. Bribery. You can't ask for or accept a bribe, which is an offer or intent to influence your actions, and you may violate the law even if you do not personally receive the bribe. It's unlawful to ask for, a demand, or solicit or seek a bribe on behalf of another person. What's the difference between a gift and a bribe? A bribe involves a corrupt intent on the part of the recipient. With a gift, you just violate the law simply by receiving something of substantial value for or because of your official act. The State Ethics Commission fined a former public employee $6,000 for soliciting and receiving bribes from a vendor by asking the vendor to pay for the employee's damaged tire and his gasoline expenses through the project, and in exchange for processing the paperwork to ensure the vendor received timely payment and certifying paperwork that he inspected the vendor's work when in fact he did not inspect the work. Municipal employee is responsible for recommending the contractor for the town paving contract and for overseeing the contractor's work received free paving services from the contractor for the employee's driveway. I know this sounds like I'm making it up, but I'm not. These are actual cases. The State Ethics Commission fined the employee $4,000 in civil penalties and restitution. The best park. The Best Select Board is responsible for voting on the use of the best town park for private events for which the town receives a fee. ABC, a business where board member Empire Sister works, wants to use the park for an event during a weekend that is already booked by a local PTA group. ABC lets Empire know that if they can't hold the event on their selected weekend, that there may be a need to be layoffs, and the Empire Sister is one of the more junior employees who would likely be laid off. ABC is bringing its request to the board tonight. What should member Empire do?
Accuse themselves.
And what does it mean to recuse yourself? Do you sit there and just not vote?
You leave the
You have
room.
to leave the room.
Leave the room, exactly.
Mhm.
In the promotional materials for an upcoming event that the town of Best is sponsoring, the select board included nearby restaurants in the list of places for meals within 5 miles of the event, including Paul's Pizza. You remember him, he read the pizza menu. And Best Family Restaurant. Best Family Restaurant sent board member Gala 2 gift vouchers for a 4-course meal valued at $45 each. The gift voucher is accompanied with a note stating that they really appreciate the town's endorsement of our restaurant for the upcoming event. Gala didn't request the vouchers, but she did prepare the promotional materials for the event. Can Gala accept the vouchers? I don't hear anybody. Can I have a chorus of no? No, no.
No,
$45 times 2 is 90.
She's expecting
yeah.
something in return.
And they were, well, yeah, they were thanking her for including them. A board member should disclose any appearance of a conflict of interest. Disclosures have to be in writing and include all the relevant facts regarding the conflict, and they are public records. They have to be filed with the town clerk. A board member, I also would say that they should be disclosed at the board meeting. That's not a requirement, but I think it's helpful so that people, because people don't always go look at for the town clerk. A board member who has an actual conflict of interest cannot participate in any official business for which the conflict exists. Disclose the conflict and leave the meeting during the deliberation and action on the matter. Board members and public employees cannot use public resources for personal political purposes. Example, secretarial services, copy equipment, paper, postage. Board members and public employees cannot use their position to obtain unwarranted privileges for themselves or others, using the position on the board to get out of a speeding ticket in town, for example. The State Ethics Commission fined a former municipal employee $2,350 for misusing public resources by having a town mechanic repair his personal vehicle during town time and having a town mechanic use town resources to repair the vehicle. You guys are, you can't believe this happens. It does. The snowplow. Select board member, Mr. Baldwin, has a wide driveway leading onto a main road in Besttown. Each winter, the town plow dumps heavy snow across the apron of his driveway and the driveways of all of Mr. Baldwin's neighbors as it passes. Baldwin contacted the department head and requested that the town clear his apron of snow each time the plow passes because the amount of snow is too heavy for his snowblower and he is not going to shovel it. The department head complied last year, but there's a new department head this year. Should Mr. Baldwin request that his apron be plowed?
No.
Not
No,
in the first, right.
absolutely. He shouldn't have done it before. And he definitely shouldn't do it now.
I
Board
wanted to
member,
add one thing on that, Liz. I know we're running out of time, but we
Sure.
ran into this in town where we actually had a select board member at one point request that we go plow a 94-year-old gentleman's driveway because his family was out of town and he was very elderly. And of course, everyone felt terrible and we had to say no.
there are
Yeah.
private companies who actually plow.
Yeah, he couldn't
Yeah.
get to a medical appointment and we were like, we'd have to do that for everybody in town then.
Yeah,
Yes.
I actually had this request from a neighbor at one time when I was on the committee years ago that wanted to have the plow drivers adjusted things so it won't plow in our driveway. So I can relate to this one.
I can relate as well. I have stood in my apron so that the plow has to go around it a bit or knock me over. I do understand that. That's a personal issue of mine. Okay. Board member Gala is having a reception for her daughter to celebrate the upcoming birth of Gala's first grandchild. The contractor that Gala hired to fix the plumbing in her antique home, specifically her first floor bathroom, before the reception has been injured and Gala hasn't been able to find a contractor who can complete the work before the reception. Gala decides to have her husband finish the work, but he doesn't have the tools. Can Gala borrow some tools that no one will be using from the town for the weekend?
No.
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 Okay. False claims. You may not present a false or fraudulent claim to the town for any payment or benefit of substantial value. Exercising the MMA conference in January. Board Chair Empire submits an expense report to be reimbursed for mileage to the MMA conference in Boston. On his way to the conference, he dropped his son off at college in Providence, Rhode Island. He submitted an expense report with mileage from his home in Best to the conference in Boston via Providence and from Boston back to his home in Best. There were over 100 additional miles because of the detour to Providence in the expense report mileage. Is there a state ethics issue here? Sure is. 'Cause he didn't. Yeah, we can't pay him for dropping off his son at college. He could be subject to a penalty and for restitution of the money he received in that. It's a false claim. The State Ethics Commission fined a former municipal employee $2,000 for presenting a false claim when the employee was responsible for providing 24 hours of specialized training to all department employees. He did not provide the 24 hours of training and gave the overseeing agency written certification that she and the employees went through 24 hours of training. So they lied.
I know this claim.
Okay. You may not disclose or use confidential non-public information. Examples of documents that are confidential and exempt from qualifying as public records. Executive session information not yet made public, personnel records, medical records, proposals and bid documents during the bidding process. And if you're employees that deal with Corey or fingerprinting stuff, that would be as well. After an executive session meeting where potential wage increases were discussed for unionized employees, Ms. Gala, a select board member who attended the meeting, was asked by her cousin, who works for the town and is one of the bargaining units, how much of an increase the union could expect. The cousin was considering refinancing his home and wanted to calculate his future income. Can Ms. Gala provide her cousin with this information?
No.
Absolutely not. The State Ethics Commission fined a former public employee $2,000 who's used her position to obtain the printed Corey, that's a criminal offender record information report of a family member's political opponent, disseminated the Corey report to her family member, who then gave the Corey report to a local newspaper that published the information. Appearance of a conflict. If you cannot act on any matter that would cause a reasonable person to think that you would show favor towards someone or that you can be improperly influenced. So if you have an actual conflict, you have to disclose it and not participate. If you have an appearance of a conflict, you have to file a written disclosure with the town clerk. And if you disclose, you may participate because it's only an appearance, it's not an actual conflict. The fiance's bid. Board member Baldwin has been living with Fuji, his fiance, for, you notice all the Apple names, his fiance for 3 years now. They have joint ownership of their home in town. They have joint checking accounts and commingle their finances. Everyone sees them as a couple. Fuji is the owner of a business and submits a bid in response to a request for proposals from the town. Baldwin is a member of the team that reviews and selects proposals and believes that he can be neutral in the decision process. What should Baldwin do?
He should recuse.
Recuse and not participate. I mean, Fuji may not be, they may not have a legal marriage, but boy, for all other purposes, they seem to be married enough that that would cause anybody to believe it's not something that they can do. Board member Baldwin recently divorced his wife, Fuji. It was a messy divorce with fights about custody of the dog and division of property. The divorce is final and all matters have been resolved, including custody of the dog, who, after enduring years of bickering by the couple, chose to live with Fuji and Baldwin's adult son, Macintosh. Fuji is the owner of a business and submits a bid in response to a request for proposals for the town. Baldwin is a member of the team that reviews and selects proposals and believes that he can be neutral in the decision process. Does anybody believe that he can be neutral in the decision process?
No.
No.
And I guess they got married and then divorced.
That's right. They were married and then divorced. And the only one that suffered, I think, is the dog here. But he chose to go elsewhere. The State Ethics Commission fined a former public employee $1,000 when the employee participated in the hiring panel for a position for which his brother-in-law was a candidate, did not disclose his relationship to his brother-in-law in the hiring process, and the brother-in-law was hired for the position. Non-town employment while serving on the board. You may not act as an agent or attorney for anyone other than the town in any matter involving the town while you're on the board. You have leaving the board. If you forever ban, there's a forever ban and a 1-year cooling off. When you leave the board, if you participated in a matter as a board member, you cannot later become involved in that same matter after you leave the board for anyone other than the town forever. Personal and substantial participation includes approving, disapproving, making a decision or a recommendation, giving advice, investigating, or otherwise being involved in a particular matter. You get a 1-year cooling off period. For the year after leaving public service, you are prohibited from acting as an agent or attorney for anyone other than the town before any town agency in connection with any matters that were under your official responsibility during the 2 years prior to your end of the board service. I like the forever ban because you can't get in trouble if you just watch that one. But if in doubt, always call the State Ethics Commission. No select board member shall be eligible for appointment to any such additional position while he is still a member of the Board of Selectmen or for 6 months thereafter. That is the state law. But for you guys, for the position of town administrator, the person appointed to the position of town administrator shall not have served in an elective office in the town for at least 12 months prior to appointment. That comes out of your charter. I realize it is after 8. We have not gotten through everything. How do you want to handle this? Did you have an 8 o'clock posted time for the next meeting?
We do, but it's, we could do it any time after. How much left do you have to
Well,
do?
we have, can we finish state ethics? We did not get to the charter part.
Okay, can we, unless you'd like to pick another date, we could finish.
Or I
another
can do
time.
it out if you want to take a break now, do your meeting and come back and just let me know. We can do that too. I don't know how you want to handle this, but we are not going to make it through the rest of this in the next 10 minutes.
I believe we only have one item, am I right? Yeah, we have one item on the agenda.
Yes, we need to pass over the second item. There's another amendment that's going to be coming for that item that I found out today that's actually going to lower the price of our.
We're not going to
our
deliberate
purchase.
here on it.
Oh, sorry.
Yep.
Sorry. Thank you.
Do you want to pause this, go do your item and come back and finish it tonight?
You want to do that, Chris?
It doesn't matter because either way, it doesn't matter.
I just don't want you to, like, you can be 5 minutes late for your meeting, but if the public is coming to an open meeting, you can't really be an hour late
Okay.
or 45 minutes late or whatever. How would you like to do this?
Well, we could go ahead and open the meeting, take care of the one item, and then come back.
Okay,
Yeah,
is
so
it
let's
a
take a
different?
15-minute break from, let's take a 15-minute break from this meeting,
Okay,
this
Okay.
training. This is not a
can I
meeting. This-
leave this training open the way it is right here?
We left, yes, we actually had the link the same so people didn't have to switch.
So I should take this down. That's what I'm asking you. Is it the same
Yes.
link? It's the
Yes.
same link. Okay, so I need to stop sharing. Okay,
Hi,
so I can see everyone else. Which chief do we have here?
This is the police chief.
Hey, chief. All right,
I'm
How are
gonna
you,
go
Rick?
to the light so I can see something in here because it's gotten quite dark in this room.
all right, so I'm gonna just mute, and when you're ready to come back, I'll come back.
I can do
Okay.
it right there. It's not my normal room. I didn't realize I had the switch right next to me.
Okay, we're gonna bring the April 22nd meeting of the Select Board to order. Meetings of the Berlin Select Board are recorded and transmitted on both the Berlin Cable and YouTube. Your voice, image, and or telephone number may be recorded. This calling it to order at 8:07. We have new business to discuss the promotion of Assistant Treasurer Collector to Treasurer Collector Kathy Murphy.
Okay.
Kristen?
Thank you. Kathy is here with us this evening, so I would like to bring her forward. And while she's coming in, I'll just explain the process that we use. So we did an internal posting for the treasurer collector position. As you are aware, we had our former treasurer collector did resign. And so we've been working off of one person in the office with a little bit of assistance from a consultant on the reconciliation, as well as we've had a wonderful senior worker, Karen Velasquez, who has been helping us anywhere from 8 to 16 hours a week, which has been fantastic, but certainly not a replacement for a 40-hour-a-week employee. So after a lot of discussion, we wanted to move forward with getting the office back up to full staff. So we did post the treasurer collector position internally. We did receive the one application. Kathy was the one who applied for that position. We held a 5-person interview panel that consisted of the administrative finance team, which is myself, town accountant June Poland, Linda Barisha, the assessor, as well as I wanted to bring in someone from public safety. So this time we brought in Fire Chief Mike McQuillan, and Dee Green sat in as well from our office, in addition to myself. So we did have a interview panel. That was actually 2 weeks ago, and the panel did vote unanimously to recommend Kathy to the position. I did include her resume and cover letter in the packet. Kathy does bring a wealth of experience in this position as an assistant treasurer collector formerly. She's also worked extensively in Maynard Public Schools on payroll and payables, and she has been with us since October. One of the goals of having this position was succession planning. We didn't expect it would happen this quickly, but we are very fortunate that Kathy has stepped up to the plate as our interim treasurer collector for the past couple of months and has been working her butt off. She's here all the time. She's doing a fantastic job. I can't say enough about her, and wanting to get that outside perspective too from other department heads to make sure everybody was on the same page and felt the same way. And pretty much everybody had wonderful unanimous things to say about Kathy. I like the idea to be able to promote internally whenever we can. And so my recommendation to the select board, as well as the unanimous recommendation of the 5-member interview panel, is to promote Kathy Murphy to the treasurer collector position this evening. And then we would go out and we would post for the assistant treasurer collector position.
Is there any questions from the board?
Kathy
Well,
is here in case you
yeah.
have any questions.
Okay, then do I hear a motion?
I would move that we promote Kathy to treasurer collector.
I'll second that.
Okay. Hearing nothing else, we'll take a vote. All in favor? We'll say Keefe, aye.
Yeah.
Have to go back to this.
That's right.
Stone Eye.
Hawkins, aye.
It's a unanimous. Thank you very much, Kathy. Welcome.
Oh, you're on mute,
Oh,
Kathy. Would
she's
you like to
muted.
say a few words? Chris, if that's okay with you?
Sure.
She's having a hard time unmuting.
Oh,
Can
with the
you,
phone,
can we
yeah.
unmute her?
There
There
you
you
go.
go.
Okay.
There you go.
There I go. Well, thank you very much.
You're welcome.
I'm excited for this. Can't wait to move forward and get an assistant and see where it takes us.
Absolutely.
Yep.
Appreciate the little
Congratulations.
snacks outside your office too, Kathy. That's a nice, it's a nice
That's
touch.
a nice touch. No, it's
Good.
on my waistline.
Whatever works, right?
Yeah.
Oh dear.
Oh, well, thank you for coming too tonight. I mean, it's a little later than usual, but
No
we
worries.
appreciate it.
No worries. I appreciate it. Thank you so much.
You're welcome. All
Thank you
right.
for stepping
so,
up.
Thank you.
Kristen, if you'd like to explain again, perhaps the deferring of our additional vote this evening.
Yes, I learned so much from the training. I'm violating open meeting law. No, I started to, but stopped. So basically, we got good news actually earlier today. Initially, Select, who is the solar company on the Highway Solar Barn, which by the way has been connected and up and running for the last 3 weeks. So very exciting that we are on solar and we will be getting our first partial month bill shortly. They are changing names as often these solar companies do. So initially the request was to just sign an estoppel to accept that change in name and ownership. However, they let us know today that they actually are able to lower our price that we pay through our power purchase agreement for the solar portion of our costs. And so they said, why don't you just hold off? We're working on the amendment and we'll bring it all back together to the board on the 29th. So I would request we pass this over and take it up at the next meeting.
Okay, we'll put it on the 29th.
I like lower
Right,
prices.
So,
Definitely.
All right. Well, having taken care of all of our business, do I hear a motion to adjourn?
So moved
I'll move to adjourn.
and seconded. There you go.
All right, thanks.
Dee's like, all right, which one did what? Just pick
How do
one.
you know?
Just pick one.
All right, so Keefe, aye.
Stone Eye.
Hawkins, aye.
Okay, thank you very much, everybody. And we'll be returning to our training.
Thank you.
Good night.
Thank you, Kathy.
Ned?
Liz, you're back up, I think.
Whoop.
Liz
Drop
is
the
muted.
mute.
Let me see if I can get the right screen back up. Are you able to see, should be exercise 23 up?
Yes.
Yep.
All right, Ms. Gala is on the Best Select Board and her neighbor was recently denied a liquor license by the town of Best and wishes to appeal the decision. She asked Ms. Gala for help for completing the appeal documentation. Ms. Gala agrees to help and does not receive any compensation for her assistance. Is this permissible?
I'm gonna say no.
No, of course not, because she's on the select board and she cannot represent or help somebody with something that is going, except for the town. That's all she can do. She can't work for somebody else, even for free. Years ago, as a board member, Ms. Fuji helped to review and draft an agreement with a contractor. Years later, Ms. Fuji obtained employment with the same contractor. The contractor asked for Ms. Fuji's assistance in interpreting the agreement in a conflict with the town. Can Ms. Fuji assist with the current employer in this matter?
No?
No, it's a forever ban. She worked on it when she was an employee, when she was on the board. She cannot assist anybody other than the town on this matter. So the most important thing to remember is the State Ethics Commission is always ask before you act. They have an officer of the day who will answer any public official or public employee's questions about and give advice. But you don't ever want to say, yesterday I did this and now I'm wondering if it's okay. Because if you do that and it's not okay, you've just made an admission and you are going to subject yourself to things. So always ask before you act. And they have a phone number. Now, granted, I wouldn't be calling it 459 because you're not going to get somebody to give you an answer, but call during the day, Monday through Friday, and ask the questions before you act. Is it okay if I do this? You know, my sister's former husband is this, is that, does that count or doesn't that count? What do I need to do? And there's a bunch of disclosure forms online to help you. But I think sometimes it's more confusing than not. Ask them if they say you need to file a disclosure, then actually ask them to send you the link with the proper disclosure. It makes it easier. And then always file the disclosures with all of the information with your town clerk. Any questions on state ethics, other than it can cost you a whole lot of money if you make a mistake?
Can I just ask a question on the approving executive session minutes?
Yes.
So we were going to try doing it in open session. Should we do that?
No. Open session minutes get approved in open session. Executive session minutes get reviewed and approved in executive session always under
Okay.
purpose 7. And then you decide in executive session if you're going to release any of those minutes.
Right. And you know, I think we had gotten a couple different opinions, and I wanted yours, Liz.
Okay, I don't know how you could have gotten a different opinion. The executive session minutes have to, if you do them in open session, you automatically release them without anybody even voting on whether or not to release them, because you did it in open session. So you have to do it in executive session to decide whether or not to release them.
Right.
So I was told it was a 2-step process, that you voted to approve them in open session, and then you would also have to vote to release them. So apparently I was told incorrectly.
You take them into exec, so you do start an open session under, and you take a vote to go into executive session under purpose 7. And then you go into executive session, you review the minutes, each one of that you have. After you review them, you decide whether or not any of them can be released. Let's say that, you know, the minutes from your last session cannot be released, but the ones that you didn't review from 6 months ago can be, because you've already purchased the property and it's all done. So, okay, you can release those minutes. Those minutes then get released by announcing in the open session, next open session, that you have approved and released those minutes. But the decision to approve and release them happens in executive session beforehand. Perhaps that's where the confusion is. After you agree to release them, then you have to say it in open session and list the minutes that have been released, the executive session minutes that have been released. Does that clarify it?
So
Yeah.
Liz, are you saying that executive session minutes cannot be approved? They have to be approved and voted on to be released at the same time?
No, you could approve them and decide not to release them. You can approve them and decide to release them.
Then why can't they be, if they've been reviewed prior to the meeting, then why can't they be voted on to be approved as to the content of the minutes during an open meeting?
Because because if you approve them in an open meeting,
Mhm.
they now are a public record. everything that you do in an open meeting is a public record. And if you need to keep them confidential because the purpose for the executive session has not yet been extinguished, that purpose still exists, you have to do it in executive session. So the way you do it is every meeting that you have an executive session has an open session, which includes the vote to go into executive session. And those minutes include that vote. Then you have an executive session set of minutes for what you
That's
did in
right.
executive session.
Yep. Mm-hmm.
Now, next week, I'm going to have another meeting and I'm going to go into executive session under purpose 7 to discuss to review the minutes from the last executive session. I look at the minutes and I say, okay, they're correct. And I say, minutes, I'm not going to release them. So the minutes are approved, but they're not approved for release. They're approved as to the content, but they're not approved to release them. We're not going to disclose them yet.
So they would not go on an agenda then if at an open session meeting, even to announce that they've been approved.
Correct. When they're released is when they go out there. So
So
people can ask for them.
I remember, Liz, that, you told me a long time ago that, documents that you have, like executive session minutes, if you have them in front of you at an open session meeting, someone could say, I want a copy of that.
If you've discussed them and they've been used at the open session, yes, and you wouldn't want to do that.
Right.
I mean, you might have them in your pile of stuff, but you're not going to talk about them, refer to them, or read them, or anything, because those are going to stay for your executive session minutes.
Right. But if you do talk about something and you've got the documentation there, someone could always ask, can I have a
That's right.
copy of that?
Yeah, you executive session, it's, the things that keep confidential are in executive session. The public stuff is public. 2 separate piles, 2 separate things. When the purpose for the executive session is no longer there, let's say you're buying a piece of land for something to expand your soccer field, and you're buying some land. The negotiations of that land and how much you're willing to pay for it or not, whatever that is going on, that's in your executive session minutes. Because you don't, you're not going to tell the owner, well, gee, I might pay a little bit more, or this is the only piece of property we can use, whatever. But once you've purchased it, and assuming that you're not purchasing any other land around it that might impact those negotiations, then it's over with. And then you could release those. And then once you vote to, you might not release them till the whole sale is done. You wouldn't release them. So you might approve them at the next meeting. They'll sit there approved. And then after you actually own that piece of land and to expand, and there's no getting it back, nobody can turn around and say it's not done. You own the land, you can say, okay, I can release those minutes. And then you would announce, you take a vote in executive session to release them, and then you would put it on the open session minutes and announce it at an open session meeting that those have been approved and for release.
Okay.
And people could ask for them.
Okay. I have one other quick question. Do you have a policy that you would recommend for public comment?
We can give you one. We could draft one. If you want to send us the one you have, I can see if I can revise it for you, or if you'd like us to do that. I mean, I think the board has to decide during an open session. This is a policy. Policies are discussed in open session about, does it want to have it at the first meeting of the month? Does it want to have it at every meeting? How long does it want to be? How long should, I personally think 15 minutes is enough. If it's going to take more than 15 minutes, I think if there's a particular thing that's going on in town that everybody wants to talk about, then I think you have a longer one, right? When our town was thinking about having, before we had the outlet mall, there was the racetrack, and everybody had an opinion about whether we should have a racetrack. So you might hope the select board might have held a special meeting just to let public comment talk about that, kind of like a hearing, so that you could hear from the public, right? If you have something big or serious or that's going to impact the entire community, then you're not going to give them just 15 minutes. But for your general meetings, you have business you have to get to. It's not supposed to be a come and talk to us all the time. It sounds like you have another method, that's some kind of coffee talk thing that you do sometimes, so people can come and give you all they want to talk about there.
Chris,
We
I
did.
made a note to put that on a future agenda, and I
Okay,
gather some samples.
Yeah,
I
and we
mean,
can help you with that too. I think it's just important that the committee, the board decide how long it wants.
right,
And, you know, I think it's important not to have unlimited, like if it's 15 minutes and there's only one speaker, that they get 15 minutes. No, everybody should get the same amount of time. And they can take less time, and they can't, I think there should be, you can't give your time to anybody else. You're recognized, you can speak up to 3 minutes. At 3 minutes, time is done. If you're in the middle of a sentence, you still go. We're not gonna let you finish the paragraph.
right. I think I was more concerned with the one that we have. May sound a little bit like, what was it, Southborough?
Southborough? Yeah.
Yeah.
Then we'll have to change that.
We'll have,
So-
yeah, we'll have to take another look at it.
Yeah.
So
But
that's why I was,
days for training, we can't look at that right now because
okay,
that,
yeah,
right, but we could
All
put
right.
it on an agenda, the future agenda.
sure.
So we have roles and responsibilities of the board and the town administrator under the charter. I would like to say your charter is new, but it's not all that new anymore. I mean, you've been living with it for a while, which is great. And so we have this chapter 384 of the Acts of 2018. 2018 is when you got your new charter. It was very exciting. And your very first town administrator. So select board is under section 2 of the charter, and the executive powers of the town are vested with the select board. If you set the goals, you make the policies for the town. And the board acts through the adoption by vote only, policy directives, guidelines. All of those are implemented by the town administrator, your chiefs, your officers, and your employees of the town. Individual members of the board shall not purport to represent the board or exercise the authority of the board except when specifically authorized by the board. So, for example, the chair of the board can sign a contract if the board authorizes the chair to do so. But individual members of the board don't speak. You only are a board when you actually are sitting at a posted meeting. Otherwise, you're just individual people who reside in town. The executive powers of the town are vested with the select board. So the goal setting, the policy, rules and regulations, interpretations of your policies and bylaws. But again, it's all exercised through your town administrator, who has the general supervision over the day-to-day matters, which makes sense. Once upon a time, you were the select board, and actually called the Board of Selectmen at the time, and your personnel board used to really run the town, all your volunteer hours, but now you hired a professional to do that, and that's what they're supposed to do. You appoint the department heads and the removal of them, and after consultation with your town administrator, you appoint town council, and you exercise your general administrative oversight of these boards and commissions that are appointed jointly by the board. You serve as the licensing board. That didn't change. You issue all your town meeting warrants, and you review and make recommendations to the annual proposed budget submitted by the town administrator. You appoint, contract with, suspend, or remove for cause a town administrator, and you designate your interim town administrator in the event of a temporary absence if the town administrator is going to be out for more than 20 work days. Anything less than 20 work days, she does it. Town administrator is the chief administrative officer and the chief financial officer of the town and acts as the agent for you. The town administrator supervises, manages, coordinates the day-to-day activities of all town departments and employees, consults and advises the select board regarding policies and implementation. I mean, what you used to have to do on your own, you now have a professional to help you do that. So those are the kinds of things when Kristen said, I'll get some samples for you. You used to, before you had this charter, have to do that work. Now you have someone to do it. Your town administrator will attend all the select board meetings unless she's excused, attend all town meetings and advise the town meeting on all the warrant articles within the jurisdiction of the select board or town administrator. attend the finance committee meetings. And you know, all of this comes from your charter, which is kind of nice to pull up and read every now and then. Manage, supervise, responsible for the efficient administration of all departments. And you know, when you have somebody who's full-time looking at things, sometimes there should be changes, and that would become up from the town administrator. Direct all the departments, commissions, boards, and offices, reorganize, abolish, and consolidate, establish departments and positions. Those things happen over time, right? What we needed in 1970 or 1950 might not be what we need in 2025. So those things change over time, and we want to keep up with that. Your town administrator acts as the chief procurement officer, keeps the inventory of all the town property, administers the insurance policies of the town, oversees the maintenance, repair, and security of your property, and works with town council. One of the things that we sometimes forget is that that delegates authority and directs any employee appointed under the jurisdiction of the select board to exercise any power, duty, or responsibility which is the administrator is authorized to exercise. So she can do that. Coordinates operations and strategic planning. Those kinds of things are important because you are going to have probably a 5-year plan and a longer plan. You need to look at those things, and those recommendations would come from your town administrator. Now, those are the things the board will do. All of those things the board will do in open session, all of the strategic planning, open session, except if it has to do with things like security. If you have a plan for like IT security, which is a very big thing these days, and security of buildings and stuff like that, that might be done in executive session, but otherwise most of this is all done in open session. There may be emergency situations. The town administrator will respond to those. Remember, she's not under the open meeting law, so she does not have to post things to take action. There's no 48 hours. Receive and act on questions and complaints. Serve as the select board's public relations officer for news releases, if the board so authorizes. And basically, everything that the board once did, other than the policy and goal setting, that's a lot of that goes now to your town administrator for recommendations to you and for day-to-day oversight. One of the things before I said that if the town administrator is going to be gone for more than 20 work days, she's going to take an amazing vacation to Asia for 25 work days, then you appoint someone to serve as the acting town administrator in her absence. If, however, she's not gone for more than 20 work days, then she appoints. And the designation has to be in writing, has to be filed with the town clerk and the select board, so that way everybody knows who the acting person is in her absence. Oops, did I go in the wrong direction here? I did. Hold on, I'm a little bit frozen here. The town administrator also establishes compensation packages for all town employees who are not subject to a collective bargaining agreement with the approval of the select board and in conjunction with the personnel board. I will tell you, in my town, before we had a town charter, the personnel board used to do a lot of things. I was on it for, I don't know, more than 15 years. But we're kind of obsolete. We worked ourselves out of a job, which was kind of nice. We let the town administrator do the job, and it was actually very nice. I don't know if you over time, you may want to look at your charter and see if there's things that you want to change as you go along. But anyway, with you and the personnel board, there's the compensation plan. Powers to inquire and investigate the conduct and operation of any office or performance of duties of any officer or employee. And that every town administrator does that. They oversee and have investigations when there are reports of misconduct or graft or anything like that. Budgetary powers and responsibilities the town administrator has. And I'm not going to read all of this to you. I know we're going over time because it's in there, but I will send you the slides if you want to read it. It's also in your town charter. But basically, the town administrator is supposed to work to help establish dates for the proposed budget, revenue statements, tax rate estimate for submission to the select board. So all of that legwork that you once did maybe with your finance committee is being done with your town administrator. prepare and present annually to the select board detailed budget estimates, report on the probable amount required to be levied, submit a 5-year capital improvement program annually to the select board, ensure all operating and capital budgets are expended consistent with the town meeting appropriation. You cannot spend more than town meeting appropriates. Approve all payroll and expense warrants for payment. And in the absence of the town administrator, the select board shall approve the warrants. You seek, prepare, and coordinate and file grant applications, and ensure complete records of financial activity for the town are maintained. The town administrator has access to all municipal books, papers, documents, and information. She may, without notice, examine the affairs of any division or department under the town administrator's supervision or the conduct of any officer or employee. That basically is everybody except the school department.
Mhm.
It's actually not. That's probably something we should fix at some point.
What's that? The school
That-
department?
No, that there are town employees that do not report through the town administrator or the select board. We have what, at least Department of Health, the assessor's
Assessor.
office, the Conservation Commission, the library board, all have employees that report through their elected bodies that have no connection to the town administrator. I think that causes problems at times.
Well, then you can correct that. I mean, there are ways to amend your charter, and that there may be some charter review after, let's see, it was 2018. So usually there's a charter review that's done about every 10 years to see if anybody wants to do any changes. You might want to put that in one of your plans, and you can certainly don't have to wait 10 years, but a charter is just that. We live with it as long as it works, and if things need to be tweaked, then we tweak them. If there's a conflict between the act and the town bylaws, when there is a conflict, prior to the act will control, right? If there's any prior town bylaws that conflict with the act, the charter, the act is the charter that will control. The board, and remember, there are issues that should be and it's really hard in a small community because I live in one, and I know that whenever you go to the soccer field, the recycling center, wherever you go where you see residents, some of them, our town, the post office, sometimes outside the post office, people talk to you as board members. They tell you their issues, and they actually want you to fix their issues. But it should start at the lowest level and move its way up, as opposed to starting at the top and moving its way down. So if the board directs the town administrator determines the goals for the town by vote, individual board members can't direct the administrator. It has to be by vote at a properly posted meeting. Usually, and most of this conduct would be an open session unless it had to do with collective bargaining, for example. Individual board members cannot change the board's directives to or goals for the town administrator. All changes have to be by vote of the board. Board members should remind members of the public to comply with the chain of command to address issues, as opposed to going directly to the board members. You shouldn't be passing things down, although if you hear of things, I think you should tell the town administrator, especially if there are serious issues of theft, graft, anything that's really bad. But issues that people have should start with the department heads and not with the town administrator, and then they go up to the town administrator and then to the board, not the other way around. Outside of meetings, the select board's position is determined by vote at a properly posted meeting. So no individual board member has the authority absent a vote of the board. And select board spokesperson communicates the positions of the select board. Is that your chair?
I don't believe we have a specifically designated spokesperson.
Well, it kind of makes sense to have one. Usually it's the chair, but sometimes it's not, because the chair travels a lot, or is there some kind of, some reason why the chair wouldn't want to do that. But usually if the press has a question for did the board vote this, or did the board agree to that? Or what's the board's view on this? They usually go to the chair. And if there's been a vote, the chair can tell them what it is. If there's not been a vote, the chair can say that, that the board has not taken a position on that. Council represents the board as a whole, and attorney-client privilege cannot be waived without a vote of the entire board. We need to be really careful about this. Individual board members have to maintain the confidentiality of attorney-client privilege communication. Remember, I talked about 268A in the state ethics and disclosing confidential information. If you're a board member and you get confidential information that's attorney-client privilege and you decide to share it just because you didn't like it or you just want to share it, you've just disclosed attorney-client privileged information on behalf of the board and without authority. That can subject you to some pretty large fines from the State Ethics Commission. Follow select board communications with community members. You should follow applicable bylaws and policies and procedures. So if someone's complaining to you about something and it should go, it's about the DPW's plowing, they should go to the head of the DPW. They shouldn't start with you. Board members may only take action as a properly posted meeting. You can't say, well, let me call the DPW, head of the DPW for you. No, you call. If you're a member of the public, you call and talk to them. Direct individuals to follow town policies and communication protocols. Remember, moving from the lowest level up as opposed to the top down. And if the information is properly a matter for administration, inform the town administrator. Let them do their job. Unionized employees, this does come up and you have to be really careful about this. There's unfair labor practice charges. And if you directly deal with an employee who's represented by a union and you're a select board member, it can be seen as going around the union. And if you go around the union, you've got a direct dealing issue. If you try to take action or say something to a unionized employee that might be considered chilling, or to stop them from engaging in conduct that they are allowed to do as a union, say informational picketing, you say something to them, they pick it outside your home and you don't like it and you make a threat to them, you've got an unfair labor practice charge. It's really you have to be very careful to just deal with unionized employees at the table with their union rep. When you speak, even as an individual, you are perceived as speaking as a member of the board and on behalf of the board. So you need to make it really clear if you are speaking about something within the board's jurisdiction that you are saying, I am speaking as an individual and I am not talking as a member of the board. Buff picketing. Negotiations with the best union of firefighters, Buff, aren't going well. Buff members have been picketing on the street in front of the home of select board member Gala. Firefighter Fran lives next door to Gala, but is not a Buff leader and is not on the union's bargaining team. Fran has been serving hot coffee, water, and cookies to the picketing firefighters and permitting them to use his restroom. Yesterday, Gala brought Fran some tomatoes from her garden, as she has done for decades. While presenting Fran with the tomatoes, Gala said, I'll remember the names of every firefighter picketing, and we'll see how happy they are when the new COLA is 0. It would be really helpful if you would talk to the other firefighters and see if they would accept a one-time payment in lieu of a percentage increase to get this contract settled. Any issues with what Gala said?
I think so.
What issues?
Well, she's talking about the union negotiation stuff and threatening them even.
So you've got threatens them,
Right.
so there's chilling. She's got the picketing, which is they can do. They
Right.
might need a permit, but they can do it. And she's talking to a non-union leader about union negotiations. So she's direct dealing with an individual. She can't do that.
Right.
The pothole complaints. Nobody ever gets a pothole complaint, right?
No.
No. If it's not plowing, it's potholes. Select board member Baldwin golfs with several neighbors. Last Saturday, while on a golf course, one of the neighbors, Paul Particular, complained that there are some large potholes on his road near his driveway. And when he backs out of his driveway, he frequently hits one of them. Paul takes particularly good care of his vehicles, and he doesn't want to damage his tires, wheels, or vehicle by hitting the potholes. Paul asked Baldwin if he can have the potholes fixed this week. How should Baldwin respond to Paul's request?
Call the highway department.
Right. That's what I said.
Exactly. I can tell you, potholes are like, if you fix the potholes, everybody loves you. Frank?
And there's no issue with providing the phone number or email address for the highway
Absolutely
department because that's public information anyway. So
No,
it's
that's
not like
perfectly
saying here,
fine.
cell phone number to the department head,
And they actually could find the phone number themselves if they just went online to the town, but they just want to tell you because you're at the top. Now, Ms. Empire, the chair of the Best Select Board and longtime member of MAD, Mothers Against Drunk Drivers, believes that town employees should be role models for citizens. She heard that Frank Fast, an employee in the Best Public Works Department, was stopped on Cape Cod last Saturday night driving 85 miles per hour in a 35-mile-per-hour zone and may have been charged with driving under the influence of alcohol. Empire wants to take immediate action. What can she do and what can't she do?
Well, I think she could tell his supervisor about this, but she can't actually fire anybody or do influence that should be fired. I think it's providing some information, especially if it's a violation of town policy.
Right, so she can tell the town administrator. I think it might be better to go that way than to skip the town administrator
Yep.
and go right to the department head, because the department head might feel like there's some kind of influence, but
Yep.
and we
I think
don't
it-
know if it's true, but I mean, okay, she heard it. She can tell the town administrator about it, who can do an investigation and find out, especially if Frank Fast happens to be held over for drunk driving and didn't come to work that day and may have been called in sick. Because if you're being held in jail or somehow you've been held, that's not a sick day.
Liz, what if it's a licensure issue? So say their license gets suspended and they're driving trucks and they have, it affects their CDL. Do we get notified by DOT or the DMV if something like that happens?
Not usually. So we
Okay.
usually want our employees to tell us if their license has been suspended. Oftentimes they feign sickness or they just don't tell us until we discover it, and then it's a big problem. Or they'll tell their coworkers and somebody else drives and they write shotgun. Gala and the budget. Best Select Board member Gala wants budget information from Nancy Numbers, the town administrator, sorted differently, requests a different format for the budget information, and wants to schedule a 2-hour meeting with Numbers at 4 p.m. on the last Friday of each month to review the budget and expenses to date. Numbers has been producing the information in the format directed by the Select Board for years. The format that Gala is requesting would require many hours of additional time to prepare and the purchase of an expensive new software license. Numbers calls the chair of the board and asks what she should do. What should the chair tell her?
You have to decide at a posted meeting, don't you?
Yes.
Yeah.
Exactly. No one member can ask for things different than the board. The
Right, it's more
numbers-
work.
The board, if Gala wants that, she has to put it on the agenda and have the board say, okay, this is what we're going to do, and this is what we're going to pay to, for the license, and this is how we're going to do it. Otherwise, we do it the way we've always been doing it. Okay. Well, it was a little bit longer than we thought. It was 2 hours instead of an hour and a half or so. But do we have any hypothetical questions for hypothetical answers, not deliberation? And I can stop sharing so that I can see all of you, because right now I can't see you all. There we go.
I
So,
was just annoying and interrupted you, so I'm all set.
No, I thought that was helpful. I like questions as we go along. Any other questions?
I'm on hypothetical questions about civic engagement using social media.
Okay.
So there are, let's say, an issue I am passionate about on the select board agenda. I really want to paint all the trees orange in town. And it is a formal agenda item. And I would like to turn people out to support my position at the meeting. And so how would I go about doing that on social media and not violate rules? Because if it's a public social media, there's a chance other select board members will see it.
So it is going to be very difficult to do that, but I guess you can, there's nothing wrong with telling people what is on the agenda and inviting them to come, right? Because that's not saying how to vote. It's not saying how you vote. It can simply say that orange trees is on the agenda for tomorrow night's meeting. Want to remind everybody they should show up and give, with their opinions on orange trees. Can you say, I think trees should remain green instead of orange? You can say that, but then when Peg sees that and
Right.
says, well, no, orange trees would be better. And Chris says, what, orange? I love purple
Right.
trees. Like,
Right.
we've now got a deliberation going on.
Yeah. And then so similarly, if it's not an issue, I have an bit like, I don't know my answer. I think there's a town problem, and want to get feedback from more than just the bubble that I happen to live in on a particular town issue. And so, how far on social media can I go? Here's something that's coming up in the select board agenda. What do people think we should be doing? Knowing that I am not going to engage any of them on that topic, and that Peg and Chris are also smart, and we're not going to engage anybody or make our own commentary on the topic. We're just sort of, hey, what do people think of, tree color in town? I'll stay with that
Well,
topic.
I suppose if you're not putting your opinion, it's kind of like having a social media public comment
Yeah.
on a future agenda item. That's not a deliberation, right? Because there's no opinion from you, from Peg, or from Chris. But if Peg and Chris decide to
Right.
give their opinions, now you've, on that same social media, now you've got a open meeting law violation. Now, I heard that Peg is doing coffee talk,
Well, we're all doing coffee talk. It's
We all
publicly
are.
posted.
but not together.
No,
All
we are,
together.
but it's an opportunity, Liz, for the residents to come to us. We make it very clear in the beginning. We, Scott and I and Chris, we do not deliberate, we do not discuss, we do not vote. We are there to hear what is on people's minds, and we'll take notes and we'll follow up with things, but there is no, hey, June, absolutely, vote, 1, 2, 3, yay, here we go. There's none of that. It's just an opportunity
All three
with
of you
town
there
meeting coming
together?
up to talk
All
about.
three are there together to listen to what the public has to
Yep.
say on a variety of topics that are, it is an
Mhm.
agenda. I think we have a disclaimer we read even in the beginning saying, I know it may be frustrating for you folks, it's frustrating for us too, but we are not allowed to comment
Yep.
on the things that you people comment on. We're
It's
allowed to listen to
posted.
them, and it might result in future agenda items, but we do not deliberate or discuss the things, but it's for all of us to see things. In some
Mhm.
respects, all of us to sometimes present on topics
So I
that
went
are
to
on the
go
agenda,
and tell
just like the
Ron,
budget.
and I
Okay, so
found-
we're not going to do a attorney-client privileged communication during this training.
Okay.
Hypothetically speaking, a deliberation can occur even when nobody says anything, because you all have facial expressions. You have smiles, you have eyebrows, you have rolling eyes, you have sighs, you have heads down, you have big smiles sometimes. So deliberations, I'm hypothetically speaking, if I were to have been asked about those talks, I would have posted them.
They
as
are
they-
posted.
They are posted.
They're
Oh,
posted meetings. They're all
oh,
posted meetings.
oh,
Oh, yeah.
fine. Okay, fine.
Yeah, yeah.
You take minutes, you post them. I'm feeling much better.
Yeah,
Okay,
yeah.
I thought you
We've
were,
been doing this for 7 or 8 years. This is not a new thing to be doing.
okay, no, but it's fine. I got the impression it was one of you doing it. Then you told me that all of you were there and nobody
No.
mentioned that it was posted. So,
No,
No,
it was,
it is
it was Peg's idea, that's all.
Mhm.
oh, got it. All
Yeah.
right, so that's fine. That's okay. That's basically public comment
Mhm.
for a whole
In a
session
large forum, yep.
in a large form with some coffee.
And maybe that's why we don't have
We
any
also
public
have-
comment during our meeting.
Yeah.
Well, and there's always a topic or two or three that we intend to discuss in, in case members of the public aren't commenting, or, there's a reason for us to be there. So we post that on the agenda, like this time it's town meeting. So
Right.
we'll go over the warrant, the budget, and then answer any questions people have about that. But folks are also free, as Peg said, to share those questions or comments with us that they have, but we won't respond to those that, don't relate specifically to the warrant or the budget, which is posted on the agenda.
I think you have open town meeting just like I have in my town. And one of the things that I have found is very interesting is that as people come into town, especially from other places that didn't have town meeting, they don't know how town meeting works.
Mhm.
And having an opportunity to ask you questions about things, or to at least ask how town meeting works, or to tell you, that is really very valuable, I think, for them. Just to know, gee, do I get to speak? How do I recognize? What is all this motion? And what does that mean, point of order? Like to have something like that is really helpful, I think, for new members and for people to feel comfortable when they come. Um,
And now we have clickers. We didn't used to have
Town meeting-
clickers.
Town
We-
meetings, yes.
Yeah,
For voting.
for
Mhm.
voting. Yeah, in my town, when I first started, the moderator used to call people by their names, and if you were new, he'd call you by what you were wearing. And I think I've arrived after 30 years here because I'm now recognized by my name, but at first I was recognized by the woman in that jacket. And it is, and we used to stand up when they were on, like, let's say the firefighter contract or something, they'd ask for a standing vote. And it would be different than the voice vote because the firefighters would be there pretending to write down everybody's name. I always thought that was really kind of amusing because I never worried because I know that the firefighters are not going to take out that list and say, which way did Liz? Was she standing or sitting before they come to my house? They're just going to come and do what they do, right? But it was just kind of funny to watch it. But yeah, I think it's great that so long as it's posted, that's a wonderful way. That's probably why you have no public comment at your other meetings, because you do it then and people have an opportunity to communicate with you.
we do it, we do it about what, quarterly?
Mhm.
So, it's usually the same time or the same month of the year for all four of those. I mean, they're even on the calendar that we approve.
No, that's good because then people, that's probably why your meetings can go more smoothly without having a lot of disruption, or they come there instead of to the meetings to do it.
Could be.
Yeah, but you do still have to watch out for the social media because people are getting more savvy and they are finding it's easier when you have a board of 5 or 7 because only a couple people and you never get a quorum. But with a board of 3, as soon as you've got 2, you've got a quorum. You're just more susceptible just because there are so few of you.
So as far as the act, I just had a question about, say, for example, I know we used to do all of the evaluations of, the department heads before we had a TA.
Mhm.
And now Kristen does that.
But you do hers.
What's that?
You do hers.
Yes, we do hers, which we're working on. But she does the department heads. Would it be out of line for us to ask for the information as a board from how did the department heads do in their evaluations, or no?
If she's doing the evaluations and the evaluations, if you asked for that, it would have to be in public session.
Yep.
And frankly, I think my view of this, and I have to go back and check it, but I think she does the evaluations of, if I'm correct, of everybody under your jurisdiction under
Right.
you, except you do hers. So it's, you trust your town administrator. If you, excuse me, but I'm going to just say this. If you don't like what your town administrator is doing and how your department heads are doing, then you replace the town administrator. But you don't try to review her job of doing that and say, well, gee, she gave the chief an exemplary, but I think the chief is just proficient, or the chief needs improvement. But like you can't second guess what she's done.
Right. I just didn't know if you could ask for the information.
I'd say it's if it's not a public record, then no.
Okay.
I don't think you should ask for the information, and individuals couldn't get it. Individual members can't get anything unless the board asks for something as a board. Individual members could never get it except as a public record.
Right.
And wouldn't get a performance evaluation as a public record. Although the performance evaluation of the town administrator is a public record. And it's
Yes.
done in
If
open
you're
session.
If you're
Mhm.
discussing it too, you're getting that into professional competency, which has to be posted in an open session and the person has to be invited.
Yeah. Yeah. I was just curious. And things that we as individual board members would like, we need to ask for it to be on an agenda so that we can discuss it and see whether all 3 of us want it.
Exactly. That's the example that I did with the numbers, Nancy numbers, and the Gallo wanted the numbers to be different. presented differently.
Right.
Well, sorry, Gally, you don't get that, because until the whole board wants them differently, or they might agree with you, but you got to go through the board. You can't, because the town administrator works for one board, not 3 board members.
Right.
So until the board directs her, you can't have individuals directing her, because then she's running in different directions. And sometimes you all don't agree with each other. There's only 3 of you, but you may not all agree on a direction that should be taken. And if one is telling her to do X and the other one's telling her to do Y, she's in a rough position. You need to have the board direct. And you do so with your policies and your goals.
And I think if it's a simple question or a simple, can I get a copy of XYZ? Obviously, that's something different, but you know, it's hard for me sometimes, you know, getting pulled in different directions. That can sometimes be tough to know where to go, because I obviously want to provide the information. I don't want to say no and be difficult, but you know, I also don't want to upset other board members who may want something different. So that can sometimes be a bit of a challenge for me.
And I think there's some growing pains every time you get a new charter and a new way of doing things, especially where the board used to do everything, the hiring, the firing with the personnel board, the evaluating. I mean, you did it all. And it's wonderful that you hired professionals to do it, especially since sometimes you know, in my community, the chair of my select board for years was the person who delivered my mail, and I'm not sure she had the expertise. We don't always get, like, you get who you get, right? Sometimes you're fortunate, people stay and they know what they're doing, and that's great. And other times you have people who could come in and do hiring by asking illegal questions and putting us at terrible risk. So it's really kind of, it's good to use professionals. We have liability if we make mistakes. So it is great. Sometimes we have great people, and sometimes we have people who don't know what they're doing. And I think that's always the risk. But when you let a town administrator do their job and you just hire that person, you're less risk. And remember, works for one board, not 3 members.
Yeah. You know, I have to laugh when you say that, because you know, I remember back before we had a town administrator, and thank goodness we voted the Town Administrator Act, because I now have my life back.
It's true.
Oh
It's
my
true.
gosh.
I mean,
Eh,
it's amazing what people have given to their
Yeah.
community.
I
And
mean, you remember, June, I used to come in your office and say, what, you know, what are we going to do? And now it's like, oh God, I can just go home and forget about it.
Yeah, it's nice to be able to just walk away. Just walk away.
Sorry, Kristen.
Kristen do it. And that's my
Exactly.
job. Well, and
Yeah.
that's where I know I'm always a pain about liability, but that's really my job, is to make sure, and liability is constantly on my mind, whether it's in the HR sense, the financial sense, the legal sense, because I want to protect all of you and protect the community. So, you know, it's not
Yeah.
about me being a pain in the butt. It's really like, you know, I worry about that constantly, and I look at that from every angle with everything that I do.
And just because I've been doing all this volunteering for the town for so many years, it's always on my mind too. My gosh.
And things
Well,
have
I
gotten
hope
so
tonight
much
we-
more complicated.
Yeah.
well, I hope tonight helped reduce some possible liabilities, at least for you personally, because none of you get paid enough to get fined by the State Ethics Commission. And I think that the open meeting law is something you just, it's so easy to violate it, especially when you only have a board of 3. So
Yeah.
hopefully that will help, and will reduce the number of things that rise to any kind of litigation.
Well, thank you so much.
You're welcome. I did go over, and I apologize for that, but
That's okay.
I like answering questions as we go along so that we can get to what you really want to know.
Yeah.
All
Thank
right.
you,
I
Liz.
will send Kristen the slides if you'd like them,
Sure.
because the recording doesn't do you any good without the slides.
Right.
Chief, you just emerged from the dark.
Hey,
He's
Chief, there
sneaky.
he
You
is.
gotta watch him.
His alarm went off. Woke him
You're
right
taking a
up.
nap. He's back.
How'd you learn a lot, Chief? Uh-oh.
I just got a lot going on in the kitchen, so
Okay.
we've been making lunch for tomorrow, getting food prepped, so.
Bye.
All right.
Good night,
Well,
everyone.
Thank
Thank
you.
you.
Bye,
Bye.
good night.
Night.